The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. We have 6 cases on our agenda today, but only 5 set for oral argument. We'll take a brief recess at some time, probably after the 3rd or 4th case. We'll start with Springer versus Grisham, 23-2192. Ms. Carter, ready? I meant to say that I hope all of the attorneys are getting double pay for coming to Denver in this weather. It's we get paid double, as you might expect. So.
Good morning, and may it please the court. Janet Carter, and I represent defendants. I'd like to reserve 5 minutes for rebuttal. This case should be dismissed for lack of jurisdiction, but if the court disagrees and reaches the merits, it should hold that Mr. Springer is not likely to succeed on his Second Amendment challenges. On jurisdiction, this case is just like We the Patriots, and the decision there establishes that Mr. Springer lacks standing. It applied long-standing and familiar principles of redressability to hold that any injury from the public health order is not redressable when a separate, unchallenged law prohibits the proposed conduct. It also confirmed that it's the plaintiff's burden to identify specifically the parks or playgrounds where he wants to carry. Here, Mr. Springer has not identified any specific park or playground. Even if this court were to draw a very generous inference from his declaration, the only park he conceivably might refer to is one expressly covered by Albuquerque's administrative instruction. Therefore, under We the Patriots, this court cannot provide any effective relief, and he lacks standing. Now, in his supplemental brief, plaintiff's only argument for distinguishing We the Patriots was that he claimed he had evidence that the separate overlapping laws were not being enforced. But then the only evidence that he came forward with to try to prove up that claim was completely irrelevant. All he pointed to were 2 news articles in which the county sheriff said that he wouldn't enforce the public health order, the law that Mr. Springer is challenging in this case. Neither article said anything about enforcement of the separate overlapping laws. And it's
why? Did he say why he wasn't going to enforce it?
The first statement that he made was before Judge Urias ruled in the district court. So I think at that point he thought that there was uncertainty around it. In his second,
he said, well, go ahead. The second reason was? Well,
the second statement that the news organization reported came after Judge Urias's opinion, and I think he said something like, we're focused on other issues. But of course, I think the most important point is that the state police were enforcing the public health order. So there was already an authority that was responsible for enforcing it. So the fact that he said, my office is focused on other things, I think is very different from suggesting that when he's the only authority responsible for enforcement, as is the case with respect to the Bernalillo County ordinances.
Maybe I'm getting the articles confused, but I thought he said that he didn't think we should enforce these against law-abiding citizens. Didn't he say that? Well,
he said that he did criticize he expressed some criticism about the public health order. But again, he didn't say anything about the Bernalillo County ordinance.
No, but if the reason he wasn't going to enforce the state order was because he didn't think he should be enforcing that type of law against law-abiding citizens, then that reasoning would apply to the county ordinances also, would it not?
I think if it was a constitutional concern, then Judge Urias's decision, as well as the wide range of decisions across the country now that have upheld prohibitions in parks and playgrounds, would have allayed that concern. I think a big piece of that was a concern about it not being necessary for him to do so when there was already an authority responsible for enforcing it. But another piece of this is that Mr. Springer has never suggested and never named any park or playground in Bernalillo County where he wanted to carry a firearm. Under the clear terms of We the Patriots, that was his obligation, and particularly if he wanted to take advantage of this suggestion, which I submit is purely speculative, that there's some inference that can be drawn from the position about the public health order to the position about the separate Bernalillo County ordinance. In order to take advantage of that, he would have to have established that he wanted to carry in a Bernalillo County park. He didn't do that.
Counsel, the redressability question is informed, of course, by this, what looks to me to be sort of a layer of other ordinances that prohibit the same conduct. But my understanding from the briefing and the record is that there's a lot of litigation over maybe some of these lower ordinances as well. Has that status of that litigation changed at all in any way that informs the case that's before us?
The status has not changed. So there's a challenge in New Mexico State Court, in the Supreme Court, to the governor's authority to declare the emergency in the first place. That was briefed. I think it was argued in the beginning of last year, or perhaps even earlier, and no decision has issued. And then there's a challenge to the Albuquerque administrative instruction and its clarification of how state law applies in the city of Albuquerque. And that case has been stayed pending the resolution of these cases. So no development in either one of those decisions.
Counsel, could you help me understand, are you making two alternate arguments? I mean, could you prevail under either one that you're making, either that no specific park named and overlapping laws? Would either of those work in your view, or is one preferable to the other?
So the argument, they're connected is the answer. The reason that this court said in We the Patriots that a plaintiff has to identify a specific park where they want to carry, excuse me, that was part of its redressability analysis. So the reason that it said that was in order to determine whether there was an overlapping ordinance applicable in the places. And because if there are overlapping ordinances, then redressability fails and the plaintiff has not established standing. I'm not here arguing that the failure to identify a specific park defeats injury in fact, although I think the court could also reach that conclusion. But again, I think my argument is based in We the Patriots, and I believe that what the court was, when the court said in that case very specifically, we think that it is plaintiff's burden to identify a specific playground that they plan to visit. When the court said that, it was part of its redressability analysis. Does that answer your question?
Well, I guess so. I mean, you said you're not here to argue that the lack of specificity dooms the case. Why are you not arguing that?
Sorry, I do think it dooms the case, but I think it dooms it under the redressability prong of standing rather than under the injury in fact prong of standing.
Okay, thank you.
I'm happy to continue answering questions, but I'm also happy to sit down and answer any further questions on
Counsel, I read your brief
rebuttal.
to say that if we were to agree with you that Mr. Springer lacks standing, that defeats all of his claims for relief. Can you help me understand, looking at the complaint and the different grab bag of relief that he's requesting, how none of those survive?
Sure. So with respect to permanent injunctive relief, I think that the analysis is just the same as preliminary injunctive relief. He wants to carry in these parks and playgrounds, and the overlapping laws prevent him from doing so. With respect to damages, I think this is an instance where causation is sort of the flip side of redressability. His injury is not being caused by the public health order when he is completely prevented from doing the thing that he wants to do. And I would point the court to Judge Ide's opinion in Valdez, the second Valdez opinion, which did dismiss all the claims for relief that the plaintiff in that case sought because of overlapping obligations that prevented them from engaging in the conduct that they wish to engage in. I'll reserve the rest of my time for rebuttal. Thank you very much.
Mr. Dunn?
May it please the court. Opposing counsel, I'm Blair Dunn, and I'm here on behalf of Mr. James Springer, the appellee cross-appellant in this matter. I'm joined at counsel table by Mr. Zach Cook. And I'd like to begin by first addressing some points of clarification. And the first one that I'll address is, of course, the court's questioned over the We the Patriots case and the supplemental briefing we did on that case. I think it is important to clarify that Judge Hartz, you just asked about the rest of the statements that Sheriff John Allen, the Bernalillo County Sheriff, made. And he did say, excuse me, essentially that it was not going to be enforced at all. And his reasoning was, as the court acknowledged, that there was no common sense to it and it would do nothing to further the goals of public safety. And that does apply to the Bernalillo County ordinance. There's cross-jurisdiction as well in Albuquerque between Bernalillo County sheriffs, and they do respond to things within the city. So there is that as well. So his office at least wasn't going to enforce any of these orders, is what the very clear statement was. And that had been a statement from before. Chief Medina, when the first public health order before the Urias decision came out, said that city of Albuquerque wasn't going to enforce it at all either. After Judge Urias's decision, there was the amended that we're here today about, and then he made the statement that we've included in our supplemental brief that he was not going to enforce it himself. They would just report it to the state police. So you have another statement of non-enforceability by the chief of police at that point, or that he won't be enforcing it, maybe not non-enforceability.
Counsel, why does that matter? Why does any of this matter at all? In the supplemental brief that you submitted, I mean, I read it to say essentially, We the Patriots was wrongly decided, that its analysis was, I think in your words, quote, too shallow, and then you presented these two articles. But we are to presume that these state and local ordinances are lawful and constitutional. We're also to presume that people are going to follow them. So why does it matter what the sheriff tells the local media?
I understand, and I think we acknowledged in our brief, supplemental brief, that this court must acknowledge their presumptive constitutionality. As the court made notice of, I have the case in the state district court that's addressing the Albuquerque instruction, and that is stayed pending a decision here. But the important point is that while this court may presume that constitutionality, for purposes of Mr. Springer's declaration, he does not. In fact, he relied on those statements of public officials, and he relied on the fact that there is no enforcement of that, or there was no enforcement of that we could find or that he knew of prior to his declaration.
But does he say that he would violate those ordinances,
Essentially,
even if they're haven't been found to be unlawful? I saw that as a fatal gap in his standing argument.
I don't think that's what he said. I think that's, and there's
But not what he said, but doesn't he have to say that I would violate a law that is presumed to be constitutional before he has standing? And that's irrespective of whether some law enforcement officer would enforce it.
And I apologize, what I was saying is I think that's exactly what his declaration says. Maybe not as clearly as it could.
Wait a minute, it says what?
It says that he attended parks and playgrounds in Bernalillo County, and it doesn't distinguish between the two, and that the only thing that prevented him from carrying while he was there, was the state's ordinance. He says nothing about those other ordinances. He was aware of those. He says, I would have gone anyways, and I had been going anyways armed, but I'm no longer going because
Said he was aware
only
of
of this.
He said he was aware of those ordinances?
He doesn't say that, but he was. That's part of why I say that the analysis is shallow, and when we get to this point of further factual development will probably help with this case. But here at the preliminary injunction stage, we've gotten enough to maintain the district court's preliminary injunction, is my point. as this case goes on, his testimony would be, yes, he actually did carry on, and I know that's a proffer that's not really before the court, but he would.
I don't think that's not the way we do business. It's got to be in the record, or at the time that standing is challenged, or we can't rely on it. And we can't rely on it if it's not in the record. And it's not, I think you're agreeing with me, though, it's not in the record that he had ever knowingly violated the ordinances, or that he would violate them.
It's not explicitly in the record. It is inferred in the record, I think, from his statement. And let me give another example. So the appellants here like to say that he didn't specify any specific park. And this gets to one of our other arguments about the playground stuff. And the court will note that Civic Plaza, across from your office, has a playground in it. So that's important to note for later. But specifically, he said he would go to specific plaza, which is considered by the city of Albuquerque one of its parks or recreation areas. And he would go there and organize a protest in support of his Second Amendment right. So he did identify specifically a park that he was prohibited from going to. And before that, he emphasized that he was going to parks armed, and then no longer was able to carry them armed because he was worried about this particular order. It's inferred in there, though it's not explicit. He was already carrying in violation of those orders for many years that those ordinances have been in effect.
Apparently, a lot of people didn't know about it. I'm not sure why the governor issued this, this executive order, or had it issued, if she knew that it was already unlawful. So his ignorance would not be remarkable.
Except it's not as ignorance, and I think that that's the issue, is that the people that did know about it didn't pay it any mind, because the New Mexico Constitution explicitly prohibits local regulation of firearms. Our Constitution says they couldn't have passed those ordinances. They're facially unconstitutional right there, and the court should look at that New Mexico Constitution and see, even though you're supposed to assume their lawfulness, you can't ignore the basic obvious point that a local regulation is prohibited by our state constitution.
So you may end up having a very good lawsuit you can bring, but you've got to start again. At this point in this case, following the circuit precedent, which we have to do, I happen to have agreed with that opinion, as you know. But given our precedent and the status of this case, you got to start over. And you may have, very interesting Second Amendment issues here, but I don't think we can address them at this.
But I guess that's part of my issue, is the start over part of this.
Yeah.
Ultimately, that is something that this was presented to the district court, right? These administrative orders are part of the record. They were briefed in front of the district court. She got to consider these. So that issue is there, and their presumptive lawfulness aside, because they weren't presumptively lawful to the sheriff or to, for instance, Mr. Springer, I think that we should be able to at least go back and complete that record and have the court look at that analysis and deal with that. That's something that could be briefed below. And since we're here arguing whether or not the injunction was correct, the injunction, as this court, I think, noted, and certainly as the We the Patriots court noted, is moot because the public health orders have been rescinded. So we're here on...
We said it wasn't moot.
Well, it's no longer in force.
Yes, okay.
Okay, so it is not moot because we need an answer on this for the next time it comes around. But it is, as far as Mr. Springer's concerned, no longer causing him injury. And I think it's important to note, his declaration doesn't talk about just planned injury in the future, right? Something in perspective. It actually talks about he was deprived. That's concrete and particularized. It says that he was. It may not specify which parks he was no longer able to carry in, but it does say that he went to the parks. So this idea of standing, I think we should be able to move past. Turning a little bit more to the merits, if we could just briefly, as I noted, we have, of course, the cross appeal, and we're asking for the court to look at what the district court did with regard to playgrounds. And as the court can note, probably judicially, across from your office, there is a playground inside of a park. And there's this weird, and I'd like to give an example. So Mr. Springer goes to a park to watch his kids play on one side, scholastic sports, as he declares he would do, and then his younger child plays in the playground equipment. He goes armed because in Albuquerque he thinks that's prudent to defend himself and his children. And one of his younger child falls on the playground and scrapes her knee on the equipment or something. He's carrying his firearm. The way that the ordinance reads, even though he's lawfully carrying inside of the park, to step across the line, wherever that might be in a playground, maybe onto the wood chips, to go help his kid, he would now be acting unlawfully just to do that. It's a nonsensical distinction, and I think the Brady case, if I'm saying that right, actually, in Judge Timkovich's concurring opinion, which is relied heavily on in the Coons case, really explains that subcategory of property within a property, like a parking lot to a post office. You don't have that issue of the sensitive place inside of the post or outside of the post office in the parking lot that you do inside of the post office. And so to declare the sensitive place inside of the non-sensitive place when they're really a sub-feature of each other, I think caused some problems, and that's why we were actually asking the court to address that in Judge Riggs's order. Which brings me to more to the merits. I think it's important to note that in the third brief from the appellants, they talk about the Rahimi case and that Judge Riggs relied on a historical twin. At the appendix at 95, we made note of this in our fourth brief, the district court specifically disclaimed against that she was deciding this on the basis of a historical twin and relied instead upon just a historical analog. And we think that she reached the correct decision, and that of course gets to the argument back and forth about what is the correct historical analog and what that is. And again, I think that Judge Timkovich's concurring opinion in Brady actually, I think, Bonadai, I don't know. I think that actually gets to that point of explaining why in this circuit, Judge Riggs is more, her decision is more in line with the precedent from this decision, from the Brady decision, which was prescient and still in line with Bruin, to not decide that every place that has children in it, which is essentially what the appellants are asking for, is a sensitive place that can be regulated without question.
Counsel, can you help me with a vexing question regarding what has been referred to as the safe harbor, or the presumptively lawful regulations that arises in Heller and then is, of course, repeated in the Supreme Court's 3 follow-on decisions. And particularly after Bruin, and figuring out where the presumptively lawful regulations fit within the Bruin framework. What's your view on, I'm assuming from what I just heard you say, that this would be analyzed under Bruin Step 2, because Mr. Springer gets through the first step. And so if we're at Bruin Step 2, how do we factor in the fact that the court has said that these types of sensitive places regulations are presumptively lawful into the Bruin framework?
I think that's exactly the point that we have to get to. That's the larger issue in this case, is what is the correct historical analog in that second step. I think it's important to note that the district court, with the evidence in front of her when she issued the injunction, and there was a bunch of later supplement of additional historical references and cites and explanations from articles and whatnot, at that point she was correct. And that's the point where she made the decision that you're at today. The later add-on of all these other arguments about the tallying, I'll call it, of the different parks and playgrounds and history, I think is too little too late. But more importantly, I think it's still incorrect. And to answer your question, I think that the correct place to look is before ratification and immediately after ratification. I'm not saying you don't give weight like they say we do, but you don't give weight to that Reconstruction era stuff. But let's look at when that Reconstruction era type of information that they've supplied the court really comes in. You're talking about stuff that's perhaps 2 decades after Reconstruction versus stuff that's right before the ratification of the Second Amendment and right after. And I think that the court should consider all of it. But the district court, I think, got it right in her analysis that focusing on that area first is where she should look. If there was no answer, and I think there was an answer in the framers' time, then you look back to that later time as for some sort of example of where the country is. But at the time of the ratification, that's where I think you look.
But in terms of the weight of the evidence that New Mexico would have to bring forward, does the fact that the Supreme Court has declared these types of regulations presumptively lawful lessen their burden in any way?
I don't think so. I think that Bruin still stands for what it stands for, and and the court should strive to get as close to what Bruin says. I don't know that there's, even the Rahimi case, I don't know really lessens that burden for the state. I think it remains what it was at the end of Bruin.
Yeah, I just, we're of course trying to faithfully apply all of what the Supreme Court opinions say, and trying to figure out the presumptively lawful regulations and how they fit into the Bruin two-step framework is a challenge. And so I appreciate your guidance on that.
That is the question today. And of course, Bruin comes after Heller, we have Heller, and I don't know, maybe this means that we also need some further clarification from the Supreme Court about what the Bruin test actually says. I think that the litigation around the country and from the different circuits the court can see is not in line or completely in line with each other. And for that reason, I don't know that this court should follow along behind some of the Antioch cases or some of the others that have been decided. I think that there's enough of a distinction here. I think there's a distinction between Mr. Springer's declaration and his decision to carry and, for instance, the We the Patriots declarants. I think there is a distinction between the two, and this court should evaluate that. But that's all my time, and I appreciate it.
Ms. Carter, do you wish to? I'm going to limit you to 5 minutes, but I'm not sure you want to spend all that time even.
Okay, thank you. I'd like to speak first to the issue of Mr. Springer's declaration. It's extremely short. I don't think there is anything in there to support the suggestions that we heard here today that Mr. Springer was aware of and intended to violate these separate laws. And to the contrary, in We the Springer, what this court said was that Mr. Smith and Mr. Donk, the plaintiffs there, would presumably obey the city and county laws, and cited O'Shea versus Littleton for the proposition that courts generally assume that parties will obey laws. With respect to Civic Plaza, he did say that he was planning to, and I'm going to quote here, organize and attend a rally in support of the Second Amendment to exercise my First Amendment rights by engaging in the expressive conduct of openly carrying a firearm in Civic Plaza, but have been prohibited from doing so by the public health order. So he didn't say anything about going to the playground in Civic Plaza. To the contrary, he said that he wanted to organize and attend a rally there. The public health order did not prohibit him from doing that. It is not a park. He couldn't go into the playground because of the public health order, but he didn't say he wanted to do that. He said he wanted to organize and attend a rally. The administrative instruction made clear that Albuquerque was interpreting state law to prohibit that, a different state law, not the public health order. So Civic Plaza is completely irrelevant, and it remains the case that he has identified no place where he wants to carry a firearm that is covered by the public health order. With respect to the remand question, it seems from the arguments today that he wants another bite at the apple, but I think if this court looks at the Utah versus Babbitt decision, that was one that was here on an appeal from a grant of a preliminary injunction. The court determined that there wasn't standing, and it dismissed all of the claims, 7 out of the 8 claims as to which that standing was absent. So the fact that this case is here on a preliminary injunction is no barrier to that being the disposition. Now, my friend spoke a lot about Bonity. First point is that he relies on Judge Timkovich's partial concurrence, partial dissent, not on the majority opinion. And that's particularly important because the majority in Bonity said that language from the Supreme Court's Heller opinion, that prohibitions on guns in sensitive places like schools and government buildings was conclusive as to a prohibition on guns in government buildings. That was a case about carrying guns in a post office. And Judge Timkovich's opinion, footnote 7 of his concurring and dissenting opinion says, I part ways with the majority on this point. I think it's just a presumption they think it's conclusive. And I don't think there's any way to distinguish the government buildings part of Heller's sentence from the schools part. We obviously rely on the fact that parks and playgrounds are analogous to schools. The constitutionality of prohibitions in schools is clearly established not only in the Supreme Court's jurisprudence, but also in a way that binds this court in Bonady.
But remind me, didn't Bonady predate Bruin?
It did predate Bruin, but that part of its analysis rested solely on that language from Heller, which the Supreme Court then reiterated. First it repeated it in McDonald, then it repeated it in Bruin, and then of course Justice Kavanaugh set it out verbatim in an opinion joined by the Chief Justice.
Yeah, sure, but isn't a fair reading of Bruin to say that it was looking at how the law was developing after Heller and saying, well, you in the lower courts are getting this wrong, and when we say 2 steps, we mean 2 steps, and here's the analysis you have to apply. In other words, what we're talking about is the challenge of whether there's a shortcut, so to speak, with the presumptively lawful regulations and how now that fits in the Bruin 2-step framework.
The Bonady opinion was very clear that it was not using the 2-step, that now disfavored 2-step analysis to approve the prohibition in government buildings. It was doing that solely on the basis of that controlling language from Heller. So I agree with you, other opinions that relied on the 2-step means and scrutiny, those are no longer good law, but that is not the case of Bonady, with Bonady, and of course in the circuit, later cases have to clearly and pellucidly overrule prior precedent in order for them no longer to be binding. So that's why this court has continued to look to pre-Bruin decisions with respect to, for example, the felony prohibitor. My friend said that there were decisions.
Is up. It started at 5:55, she didn't drop it to 5, but I was just going to give you what you requested for rebuttal, so.
Okay, well, thank you for the court's time.
Thank you, counsel. Case is submitted and counsel are excused. Please get ready now for our next case, 3484 Inc. versus NLRB, numbers 24-9511 and 24-9525.
Thank you, Your Honor. May it please the court?
Yes.
I'm going to endeavor to save 3 minutes for rebuttal. The board's order should be vacated for 3 reasons. 1, it's not supported by substantial evidence. 2, the award of compensatory damages is in excess of the board's statutory authority. And 3rd, that remedy, along with the board's process, violated petitioners' constitutional rights. I'd like to begin with the remedy question first because I think it's the most straightforward. As this court previously held in Course Lab and as the Third Circuit recently held in the Starbucks case, an award of compensatory damages beyond that which makes the employees whole is in excess of the board's statutory authority. In Course Lab involved a pension fund, and the board ordered the employer to pay money into that pension fund, but it did not allow an offset for money already paid into it. And in Course Lab, the court held that that was beyond the board's statutory authority. And for that reason, among others, we believe that the remedy question is properly before the court.
Why? I mean, you haven't, how do you say that the issue was preserved?
Two responses, Your Honor.
That's my question about why, that's what I meant when I said how How is that properly before the court?
Yes, two responses, and I'm sorry, I did not hear you before. One is because we did preserve the objections. We cited to the ALJ's order and the specific lines. In Course Lab, this court held that similarly and admittedly terse objections were sufficient. And we think that conclusion is particularly apt in this case because the purpose of raising the objections beforehand is so the board knows what issues are relevant. And the board is well aware of the issues with respect to its award of compensatory damages. It continues to issue those awards. It is litigating the issue across the country, including on the Third Circuit. So there's no unfair surprise. There's no question about what issues.
You have several arguments you make in your brief to this court.
Correct.
None of those arguments were expressed in the NLRB proceedings. All you did was identify something you objected to, but the rationale behind it, ordinarily that's necessary for preservation. You're saying it's not necessary to explain why you're objecting?
Well, Course Lab accepted similarly terse objections, and we believe that we've submitted the same. But again, the purpose of that requirement is so that the board knows what the issues are. The issues we are raising here with respect to the remedies are the ones that the board has addressed several times. There's no question about that. But an exception to that 10E requirement is when the board exceeds its statutory authority. And again, in Course Lab, this court's already held that a similar award is in excess of the board's authority. So under either rationale, we believe that the remedy question is clearly before the court. Now, the board's response is inconsistent. The board says on the one hand that there's a lot of previous cases in which the courts have confirmed that the board has the authority to issue these kinds of awards, which are public rights. But at the same time, the board says that it is now allowed to award compensatory damages, although it is trying to run away from that description. But those are private remedies. An award of compensatory damages, consequential damages are private remedies. And so the board can't have it both ways. If it's public rights, it can order an injunction and a remedial order to make the employees whole, but it can't go beyond that without going into the private rights realm.
But isn't that the key, the order to make the employee whole? Haven't we held that it's an equitable remedy and allows for things such as back pay?
We're not contesting that back pay and similar items are part of the board's make whole power. But what the board did here and what it did in Thrive, the board ordered Petitioner 3486 to make the drivers whole for any loss of earnings and other benefits and for any other direct and foreseeable harms which resulting from the unlawful practice.
Which have not yet been determined, is that right?
That's correct. They have not been determined, but at issue in the determination will be the make whole award and compensatory damages.
Okay, so why wouldn't we then wait to see what happens? Let's say this order were to go into effect, and then there's a determination as to what that means and whether whether the company has to make any financial payments in that sort of last category, and then the challenge becomes ripe.
Well, it's ripe now, we believe, because at that hearing, the court would be considering, or I'm sorry, the board would be considering whether to award make whole and additional damages. We submit that it shouldn't.
Yeah, but the board could say, well, we don't think that's either within our power to do, or we don't think that applies here, and award zero.
Well, the board has already said multiple times that it is within its power.
But not
to
in
do
this case.
Yes, it is. It said it's awarding, it ordered Petitioner 3486 to make the employees whole and for any other direct or foreseeable harms.
I guess what I'm getting at is this seems to me that it could at least be a fact determination as to whether any of those harms are worthy of compensation, but that determination hasn't been made yet.
No, but this is when we need to raise these issues. I mean, the issues before the court, it needs to be addressed. This was also asked at the Third Circuit, and the Third Circuit agreed that it was proper to raise them at this time. And I'd like to emphasize that the Supreme Court has held, and this is in the Russell case from 1958, that back pay is merely incidental to the board's primary purpose, which is to eliminate and prevent obstructions to interstate commerce, and that the board does not have the power to issue, it did not set up a scheme to award these kinds of compensatory damages. Now, I would like to discuss the record to some extent. I believe that there are a number of inconsistencies in the record, beginning with the 3484 production. Now, that's the first production, and that the problem there allegedly is a question by a supervisor to a driver about whether the driver was aware of any union activity. The ALJ, first of all, found that the two companies were not alter egos and were not a single employer. That conclusion has not been objected to by the board. Yet, when the ALJ considered whether the supervisor, whether the question and the request to keep it confidential were coercive, the ALJ and the board considered actions from the second production. And this court has held, and the NLRB has held, that a single question and a single request for confidentiality do not necessarily show coercion. And so by using evidence from the second production, we believe the board, that the substantial evidence does not support that conclusion.
You're talking about the Kennedy case?
I'm sorry, Kennedy, yes.
Kennedy.
Yes, and the NLRB case is Lafayette Park Hotel, where it said that a single request to keep things confidential is not necessarily coercive.
Well, we said it wasn't coercive, I think.
I'm sorry?
I think our language was more definitive than not necessarily. It said it wasn't coercive in that case.
It said not all interrogations are illegal.
And this one wasn't because it was just a single question.
That's our, yes, correct.
What about the request or order not to, the order to keep this quiet?
Same response. And one request does not necessarily make it coercive.
Yeah, but that's not required for the second violation. It's just it doesn't have to be coercive. It's just any effort to keep things secret violates the NLRA.
No, that's not correct. And this is the
Language of that.
The Lafayette Park Hotel, which is an NLRB decision from 1998, said that a confidentiality requests are not necessarily coercive and therefore not necessarily violative of the act.
Isn't part of that analysis, though, whether there's a business justification for the confidentiality request, and if so, what was the justification here?
Well, because of the timing of these things, the movie productions are, in these cases, are done over a matter of weeks. Things need to be done. If the movie production needs to hire additional drivers, it needs to know that in advance. And again, it was just a simple question and request for confidentiality.
Well, sure, but that may be why you would say it wasn't an interrogation. She just wants to know whether there's union activity. But saying, hey, don't share with anyone that I'm even asking these questions, that seems different to me. What's the justification for that specific order?
I think it's the same thing. I'm just looking for information. Please keep it quiet. I'm just thinking about what the company needs to do in this situation. And evidence that it did not tend to be coercive is that this driver was hired for the second production. She voted to go on strike, and she went on strike. With respect to the second production, this involves the threat.
Well, it doesn't have to be effective to be coercive.
That's right, but I'm just saying the evidence in the record shows that she was not coerced, and so I don't think there's any other evidence that would tend to show coercion in this case.
Did you? I'm checking your reply brief because I don't remember you responding to the NLRB's argument in its answer brief that there was still a problem with the request to keep things confidential. Did you respond to that in your reply brief?
I thought we did, but I don't.
Check here.
Yeah, I will defer to the courts. With respect to the second production, again, this involves the threat, another alleged interrogation and the failure to reinstate. The threat, we think that there is sufficient evidence to show that the driving coordinator in that case did not have the kind of discretion that the board found. And as evidence of that, the ALJ, in a separate part of his opinion, said that the owner, Wolf, ran a top-down dictatorship. And that's in the record 817 and 818. I think that contradicts what the board concluded about the coordinator's ability to control things. Also, with respect to the equipment, I think that there were two big problems with the board's conclusion with respect to the stealing of the equipment. The board said, well, they knew, the union and the drivers knew that they had to take good care of the equipment, but that's irrelevant. The equipment was rented or owned by the movie companies or by Wolf or one of his other companies. And so the union and the drivers had no right to take it in the first place. It would be like if the movie companies had rented a building and the crew went on strike and occupied the building. They're not allowed to do it.
On that, but doesn't it require individualized, good faith or honest belief that specific individuals engage in certain conduct? And so my understanding is there are about 12 drivers and, sort of all the equipment was taken. So is the inference that they all had to participate because it was taken, or did you anywhere in the record bring forward specific evidence by named driver?
No, but the ALJ, again, this is the ALJ's, this is from record 831. The ALJ found that all 9 drivers were entitled to reinstatement because they all engaged in picketing and they all engaged in moving the vehicles and the equipment. So I don't think there's any question about which drivers. They were all involved. Not only did Wolf have an honest belief, he had to go to the hotel where the drivers were staying to recover his personal property. The property was stolen. There was no question about that. I see I'm only about 2 minutes left, and I'd like to reserve the rest for rebuttal. Thank you.
Good morning. May it please the court. Eric Weitz on behalf of the National Labor Relations Board. I'd like to begin on the Thrive remedy and in particular on the threshold jurisdictional question pursuant to Section 10E of the Act. This is a case where the employers did not raise any argument or present any of the arguments they're now making to the board. What they did do in their exceptions document was to include rote exceptions to nearly every remedy. The exact quote in objecting to the Thrive remedy was that they were objecting based on the record and the supporting brief. If you then turn to the supporting brief, which we've lodged with the court, they made no challenge to the Thrive remedy whatsoever. To the contrary, the brief was written as to suggest that what their argument was that they were objecting to the unfair labor practice findings, and as a result, no order and no remedy was warranted. But at no point did they suggest that the Thrive remedy exceeded the board's authority, that it violated the 7th Amendment, that it was inconsistent with Section 10C of the Act, or any of the other broad arguments they now present. In Course Lab, which opposing counsel has referenced, this court distinguished the Supreme Court's opinion in the 7-Up bottling case, noting that that was an example of a terse objection that was insufficient. And if the court looks at what was at issue in 7-Up, the language there was nearly identical to what occurred here. An employer had objected solely based on a rote recitation that the record and the law do not support this remedy, and the Supreme Court held that is insufficient to preserve an issue for the board's consideration. In Course Lab, this court distinguished those facts. Those facts were very different. The board had awarded a particular kind of relief unique to that case based on the facts. The employers specifically identified that they disagreed that that remedy was warranted, and in detail identified, what they were objecting to. And although they didn't include, extensive legal arguments, the board was clearly on notice that the employer was objecting to it. This is even further removed or even more unjust to the board than 7-Up, because in the supporting brief, not only did they not make arguments, they actually misled the board into thinking that their objection was based on the ULPs and that no remedy was warranted. And so this is a straightforward case where the issue was not raised. As to the extraordinary circumstances exception, which this court in Course Lab noted in a footnote without actually applying, I'm not aware of any instance of this court ever applying that exception. But some courts have looked to dicta from the Supreme Court's opinion in the Cheney lumber case to hold that in certain circumstances where the board has clearly or patently traveled outside the orbit of its statutory authority, a court can deem that an extraordinary circumstance. But that is a very limited exception. I would point the court to the Eighth Circuit's discussion of this in the Relco Locomotives case, which I think is very persuasive and illustrative, where the Eighth Circuit explained that there is this exception, but it is truly reserved for extraordinary circumstances where, for example, the board clearly should have known that it was doing something beyond its authority, such as where you had in-circuit precedent that had already clearly foreclosed a certain type of board action. The interpretation of that exception that the employers are now suggesting in their reply brief, which is any argument that alleges the board exceeded its statutory authority is now an extraordinary circumstance, would swallow the rule and the intent of Congress in enacting Section 10E, because in most cases where a party is challenging a board remedy, given the board's broad remedial discretion, the argument is that the board exceeded the discretion it has under Section 10C. In many cases, arguments that employers are raising to board decisions are based on a claim that the board somehow exceeded its discretion. And to say that in all of those cases that is now an extraordinary circumstance would run roughshod over Section 10E and would allow employers, as occurred in this case, to simply selectively and strategically not make any objections to the board and then plan to litigate an issue in the first instance before a court of appeals, which is not what Congress intended in enacting Section 10E, which is a jurisdictional requirement, as this court held in Public Service Company of New Mexico. And this is a classic case where the issue is not properly before the court. Turning briefly just to the merits of the remedy, although of course our position is the court has no reason to reach them. The opposing counsel mentioned CourseLab as supporting their position. I actually think it does the exact opposite. In CourseLab, this court held that the board had exceeded its authority because it had included a remedy that essentially, in the court's view, allowed employees to collect twice, to receive a windfall. And the court's reasoning, which is consistent with 90 years of Supreme Court and Court of Appeals precedent, is that the objective of the act, the policy of the act, is to make employees whole and to restore the status quo ante. In CourseLab, this court held that the board's remedy had gone beyond that. But the remedy being challenged here, the Thrive remedy, is by its terms limited to making employees whole for concrete pecuniary harms that are fully litigated and proven in a compliance proceeding to have been caused by an unfair labor practice. It's a classic instance of restoring the status quo ante. As the board explained in Thrive, this is not a new remedy. For 90 years, it has done this on an ad hoc basis, and the only innovation in Thrive was to say now as a standard remedy, every time we include a make-whole order, we're going to use this particular language. But it was not expanding the board's remedies into any form of private damages. It was not going beyond making employees whole or restoring the status quo ante. It is limited to the core remedial objective of the act, which the Supreme Court has recognized in those terms for 90 years. As for the Russell case, which employers are also relying on, again, I would just direct the court to that case, which I would submit also supports the board's position here. In that case, the Supreme Court was facing the question of, does the National Labor Relations Act supplant private rights of actions in tort claims in state law that employees might have? And the Supreme Court held no. The purpose of the National Labor Relations Act was to establish an agency to enforce the public rights enshrined in the act. It is not to provide damages to individual employees. It is not to adjudicate private rights. It is to determine what is necessary to further the policies of the act. And that's where the Supreme Court suggested in passing in dicta, or language that's essentially dicta, that the purpose of the board is not to provide compensatory damages to employees. But in context, what the court is getting at is that the board is an agency that adjudicates public rights. That's what its remedies are aimed at effectuating, not private damages. And that the question, which again the Supreme Court has held for 90 years, the standard of review, is when someone is challenging a board remedy, is that remedy a patent attempt to achieve ends other than those that effectuate the policies of the act? The Supreme Court and lower courts have on many occasions struck down board remedies, but it was based in situations where the board had gone beyond restoring the status quo ante and beyond making employees whole. It had nothing to do with this common law equitable distinction that the employer is attempting to insert into Section 10C of the Act. Although on that point, I'd like to be clear that the remedy here is properly deemed equitable. We are not claiming that under Section 10C, the board necessarily has the authority to issue legal damages or any kind of legal remedy. Our objection as to that statutory argument is simply that is not the test under Section 10C. In board cases, the courts do not need to determine on a case-by-case basis, is this something a court of equity did in the 18th century? Rather, the Supreme Court has already held, the question is it something that goes beyond effectuating the policies of the Act? And I would submit that the Thrive remedy.
Finish briefly, I'd like to get to whether there were any violations.
Sure, I'll just finish briefly noting that I would submit the Thrive remedy is clearly within the core of the board's policy objective, which is to restore the status quo ante.
Could we turn to the unfair labor practice?
Please, Your Honor, sure.
So let me focus first on 3484, the first. How did the question about whether there was union activity, how did that differ from the question in Kennedy? It looks to me like Kennedy controls. Maybe Kennedy was wrong, but it's controlling. Can you reconcile the determination that that question was an unfair labor practice with Kennedy?
Sure, Your Honor. Well, I'd preface my answer by noting that this area of law, the question of unlawful interrogation, is a totality of circumstances test. It's a case-by-case, fact-specific analysis, so the board has to weigh different facts on each case. In Kennedy, this court denied enforcement of the board's unfair labor practice finding in a very terse opinion. I believe it's essentially one sentence in that opinion. So not all of the contours, the factual framework of that case are necessarily explained. I think.
But doesn't that mean that it found just the fact that it was just that one question won't do it?
Well,
it seems to me that it's stronger because it didn't worry about other potential factors. Said that one question is not going to coerce anybody.
Well, I don't know that the court wasn't worrying about it. I think they were reviewing all of the detailed facts of that case, and in their opinion, they didn't get into them. I think
sometimes that means the facts they recite in their reasoning are all the facts they consider relevant to the determination. And that's the precedent that was set there.
Sure, Your Honor, but I don't think Kennedy can be read as a per se rule that anytime you have a single question that can't be an interrogation. In the YMCA case, for example, another decision from this court, again, those facts differ in certain ways, but that was a situation where you had a single instance of questioning about the union.
Single incidence of questioning, but it was more than one question, wasn't it?
Yes, Your Honor, although I
mean, the one question that was referenced in Kennedy, I find hard to distinguish from the one question here.
Well, Your Honor, I think the distinction, for example, is that the circumstances of the question here were very different. You had a situation here where the highest level supervisor in charge of day-to-day production singled out a low-level employee, called them after hours on their personal cell phone in a sort of surreptitious way, which is similar to situations this court has found supports coercion, such as locking a door or contacting an employee after work. It suggested that this was somehow some kind of surreptitious inquiry or needed to be kept under wraps. It came in the context, again, which I think is important in this case, of a course of conduct over several weeks involving all of the same individuals, David Wolf Film Productions, Ms. Ricci, the same manager, the same drivers. Granted, it was across two different film productions, but it occurred in very short order.
Well, Counselor, can you help me understand on the record, because I don't make films and hire a lot of labor to assist with that, but it seems to me that that's an extensive project. It requires a lot of time, planning, and resources. And here, my understanding is the drivers were going to be needed for a relatively short time frame for 15 days, but yet on the 3486 shoot, they approach Mr. Wolf basically on the eve of shooting the film, and it seems very tactical on their part to come at him at a time where his attention's going to be elsewhere. So I guess looking at the record then, as we're looking at a number of these determinations for substantial evidence, how does that factor in? If we're trying to determine what motivated their strike, for example, they say, well, it was a ULP strike, but it seems also pretty clear that it was an economic strike and they were using the ULP as leverage. And how much credibility can we give to them when we look at the record and, again, what I call a tactical advantage they were trying to gain with the timing of all this?
Well, I think the timing points in both directions, Your Honor, because just to briefly go through the timeline here, it's true that the union approached Wolf Productions on the eve of filming, and Mr. Wolf may have a valid objection to that. That is not the basis for the board's order. What is the basis for the board's order is after the union did so, and he was upset by it, his deputized agent threatened the employees that if they continued with these attempts to organize, production was going to move to Canada. That occurred immediately after they reached out to him, and soon after that...
Is that a hollow threat? I mean, they're all on set. They're ready to shoot.
Well, it's not
hard for us to read the record and kind of have an understanding of that. At least it is for me.
I think a relevant consideration, Your Honor, is that all of the parties here are repeat players. So when that threat is made, that Hallmark Productions, the client who is a recurring client of Mr. Wolf, these drivers recurrently work on these same film productions in Utah, that if they try to organize, all of film production is going to move to Canada. That is clearly a threat to their continued livelihood as film industry drivers in Utah. And I don't think it's a hollow threat at all. I think it's one of the most coercive threats you can make to an employee. And so it's true that they reached out to him on the eve of filming. Whether that's good manners or legitimate or not is not really relevant. What's relevant is that in response, this Hallmark unfair labor practice was committed, and all of the record evidence shows that, at least in part, in response to that unfair labor practice, the employees chose to go out and strike to protest, with the hope being that Mr. Wolf would stop threatening them and he would recognize them and negotiate a contract. That's obviously their long-term goal, just like any employees who are trying to unionize. But it's a very lenient test. Was an unfair labor practice at least part of the motivation? And I see that I'm over time, so unless there's any...
There are further questions.
Sure, Your Honor.
What about the argument made by the employer in its first argument regarding the evidence of misconduct in damaging the equipment of the company and how that could justify what the company did? How do you respond to those arguments?
Well, I think there's two sort of intertwined arguments. Before the board, the employer argued that employees had actually vandalized equipment and intentionally damaged it. The board found that there was no evidence whatsoever, number one, that particular employees did so, or number two, that the employer even believed that it had anything to do with the strike. And on review, I don't read the employer's briefs as pursuing that argument. There's one stray reference to equipment damage. They do not contest that finding by the board. On review, they make a different argument, which is that the employees should be denied reinstatement because they moved some of the leased vehicles. Number one...
That was not preserved, you don't think, before the board?
I think it's debatable, Your Honor. We haven't pressed a Section 10E argument as to that, but that was not the main argument they were presenting to the board. Whether they incidentally preserved it may be, but I think it's not a compelling argument because the test here under Clear Pine Moldings and this court's precedent applying Clear Pine Moldings is that employees have to have engaged in serious misconduct that actually coerces dissenting employees who want to cross the picket line. So traditionally that is picket line violence. It could include property damage, but it's not simply being disobedient to the employer. And what happened here is not even really misconduct because the employers are alleging that this was somehow theft or interference with their property rights. But I would emphasize number one, that the employees and the union actually contacted all of the property owners. They did not move any of the several vehicles owned by David Wolf. As for the leased vehicles, they contacted the actual owners to make sure that those owners wanted the vehicles moved to safety, and they received consent. And in addition, while all of this was going on, all of the managers and supervisors for Wolf Productions were on site, and they tacitly signed off on it, or at a minimum, they did not object. They watched it going on, and they said, do what you need to do, and there was no attempt to prevent the employees from doing this, which again was entirely in good faith to prevent damage to the vehicles.
Thank you. Any other questions? Do you have any questions?
All right, thank you.
And we'll give appellants some extra time. Give them 6 minutes.
Thank you. Your Honor, with respect to the last point about the union members and the employees calling the owners of the equipment, again, if the movie company had rented a building and the crew went on strike and took control of the building and they called the owner and said, do you mind if we take control of the building? It's irrelevant. The equipment and the trucks were in the lawful possession of Wolf. They were stolen. There's no question about it. The union can't change that by getting consent from the party that leased them. They no longer had physical control or legal title to the equipment and trucks while that was going on. With respect to the arguments about public rights, in Jharkhasi, the Supreme Court clarified what public rights were. It was a specific list of things like immigration, public lands. It did not include NLRB actions. So we believe that the public rights analysis does not support the board's decision here. Further, my friend is correct that the courts have held in certain circumstances that, or they have overruled what the board has done in terms of exceeding its statutory authority by awarding things that do more than make the employees whole. But that's the crux. The point is to restore the status quo ante. Damages beyond that are separate and beyond the board's authority. And again, I'd reiterate, the board's order here says that the employer must make the employees whole and award relief for direct and foreseeable harms. Those are consequential damages, and that is beyond the board's power. Course Lab, again, held that the board exceeded its statutory authority by requiring money to be put in a pension fund beyond that which had already been deposited. So the same thing here. If the court agrees that there are ULPs and if the court agrees that a make-whole order makes sense, that's fine. But damages, we believe, are beyond the court's authority, or the board's authority, excuse me.
You don't have to use all the time I gave you.
No, I understand. I just want to make sure I've got everything. I'd like to make one point about the threat. There's no evidence in the record, and this goes to Judge Federico's question about the nature of the threat and whether the strike was ULP or economic. There's no evidence in the record that the drivers, other than Brewer, knew about the threat. The record shows that the union members said to the drivers, there have been ULPs, but that's it. The record doesn't say what the nature of the ULPs were, whether the drivers were aware of anything. So we think that's also, the court should take that into consideration.
Can you actually help me understand again, just the record? 3 days before the shoot, they come to Mr. Wolf with an email and say, we'd like to talk about a new contract. Again, I frame that as being, I think, maybe tactical. At least you could read the record that way. But also, just they're asking for things like health benefits and retirement, but this is such a short time frame. Can you help me understand how that works in practice? Let's say they sign the contract. Would that carry on to the next project, or is that paid by the union?
No, that would just be for each individual production. That's how the practice in the injury is in the industry is that each film gets its own entity. So the contract would be between the union and the specific entity.
That would carry on to the next project?
It would not.
It would not?
It would not. It would just be for that particular shoot. Now, I suppose they could agree to it, but I think the standard is they want to keep everything lined up so that any issues with a particular film won't affect a future production. And one last point on that, there was an email from the union representative after the ULP allegedly was committed, and she sends an email to Wolf and it said, all this is about is getting a contract for the workers. This is nothing more than an effort to get a contract for the workers. We submit this was an economic strike. And if there are no other questions, thank the court for its time.
Thank you, counsel. Case is submitted and counsel are excused. We'll turn next to 24-1188, KA versus Barnes. Ms. Brown?
Thank you, Your Honor, and may it please the court. I'm Christy Brown with my co-counsel Suzanne Tahiri. We represent the appellant, KA. Parenting is a fundamental right. When it comes to a state getting involved in custody and termination of parental rights, which all states do, the state can make its cake, but the role of the federal courts is to ensure that the baking ingredients are constitutional. KA's case is about the case of a stay-at-home mother who dared to believe her daughters and accuse her ex-husband of sexually abusing them, claims also reported by the girl's school and dance studio. In return, permanent termination of her parental rights is what she received. The department sought her daughter's removal from anyone who dared report abuse, including their school and their dance studio. The department conspired to protect the father rather than investigate what was happening to the children. And after repeated accusations of abuse, the department refused to continue to investigate and instead worked to remove the children from those who believed them. The policy, parental alienation, that was aggressively used by the defendants to remove my client's parental rights was a State Department policy, not a state law, used by county departments across the state. Colorado now bans these kind of actions by Department of Social Services and recognized the policy as so out of bounds and unconstitutional in 2023 that it came in to stop the policy once it got exposed, but none of this happened in time to stop them from violating our clients' fundamental rights.
You're addressing the merits, and your problem is procedural. There's nothing a federal court, except the U.S. Supreme Court, can do to set aside the termination of parental rights. Do you agree with that? Isn't that the Rooker-Feldman doctrine?
Justice Hartz, I don't agree. I don't think Rooker-Feldman applies in this case, specifically because we're not asking the court, we're not saying the state court erred in its decision. Instead, we're saying the procedure that the department used to pursue the stripping of her parental rights violated procedural due process.
Right, but your remedy is to seek overturning that termination, and that's a state court judgment, and we can't review it. Rooker itself was a challenge to the procedure of the state court, as I recall, not from having been around then, but from reading the case. And that's the same posture here. You can't argue that the violation of constitutional rights was in how the state court reached its decision.
Justice Hartz,
You're stuck with that decision.
sure, and Justice Hartz, we're actually not arguing that the state court erred in how it reached this decision. Instead, we're arguing that the department, the county and state department, how it pursued the termination of rights against our client was
We have to
unconstitutional.
start in reviewing the issues before us. We have to start with the proposition that her parental rights have been terminated, and there's nothing we can do about that.
Well, Your Honor, I would disagree and say that
How do you reconcile your disagreement with Rooker-Feldman?
because, Your Honor, basically, for Rooker-Feldman to apply, we would have to be arguing that the state court erred. And when we're instead arguing that the state law behind it was unconstitutionally applied to our client. And so the process violated her procedural due process.
You're having to argue that the state court erred in revoking her parental rights, and you can't do that in federal court. You could have appealed or sought cert from the Supreme Court, U.S. Supreme Court, but we can't set aside that termination. And once we have that termination, that moots almost all, maybe all, of your other arguments, because they depend on the fact that she still has parental rights. If she has no parental rights, she can't challenge the statute, she can't challenge the statute of limitations.
So, Your Honor, the statute at issue actually that we cite, 19.3.612, actually still does apply to parents even if they don't have parental rights at the time. What it actually does is allows parents whose rights have been terminated to appeal longer than 3 years after their rights were terminated. And we're arguing that law is unconstitutional in application because it does not apply to her right now. When a parent's rights are terminated based on the policy of parental alienation, that statute can't apply. Instead, the statute can apply when your rights were terminated for any other reason, when your children are in the custody of the state, or if the other parent, the custodial parent, dies, you can bring a case. But because her rights were terminated on parental alienation, which always means that there is another custodial parent, she does not have that exception that all other parents would have to bring an appeal of the termination of their rights on any other basis. And so that is why it's so key to this argument that parental alienation was an unconstitutional theory used against her by the state and county departments, and why the procedural due process matters so much.
There is a state decision that she can't timely challenge the termination of her rights. Is that correct?
I'm sorry, I didn't quite catch that, Your Honor.
There is a state court decision that she can no longer challenge the revocation of her parental rights because she's out of time to do that. Is that right?
Yes, Justice Hart, that was...
That's a decision by the state court, and you want that overturned by challenging the constitutionality of the statute of limitations in the state. But what you have is a decision that she can no longer, by the state court, that she has had her parental rights terminated, and there's no way she can get them back. You agree that that's what the state court has ruled, is that right?
Not exactly, Justice Hartz. I do not think they used this law to come to that decision. I think that's part of the error, is that they don't think they can use this law. That's why we're asking for you to declare this law as unconstitutional, because she would have a separate avenue to appeal the termination of her rights in state court if 16.9.3.12 applied to her. Instead, the state court applied the appellate rule that gives her only 21 days from the termination of her rights to appeal, at which time she was in jail due to the defendant's actions, very wrongful actions against her, as we detail in the briefs. So in fact, if this court found that the lack of applying 16.9.3.12 to her was unconstitutional, she would have a different avenue to pursue the appeal in state court.
What about the statute of limitations questions as to when she was on notice regarding the rights violation? So I understand your argument to say, well, but we're looking at when the Colorado Supreme Court denied review of her case as sort of the triggering event, but there's law that says that may not be right. So can you help me understand, one, sort of when it's triggered that the clock starts to run on the statute of limitations, and also, well, maybe I'll let you answer that before we talk about equitable tolling.
Sure, thank you, Judge Federico. And I will try and reserve 3 minutes at the end for rebuttal. First of all, we think there are two specific reasons why the statute of limitations did not accrue at the time that she filed her case. First of all, it's two recent Supreme Court cases, McDonough versus Smith and Thompson versus Clark, a 2019 and 2022 cases that showed when the government used a fabrication of evidence or malicious prosecution against someone in a 1983 action, their action didn't even accrue until the state court case ended. The Supreme Court used practical considerations and said, when the state is coming against you in court, you shouldn't then have to bring them in federal court. It is reasonable for the statute of limitations to accrue once your state case is over. And we believe, while those were criminal cases, this was a civil case, it's still similar when the state is going after you and false evidence is being used. The same practical considerations would apply in 1983 action. That would allow her statute of limitations to accrue on September 7th, 2021. We filed on June 20th, 2023, or her DNN case didn't even close until April of 2023. So there's a few dates which could apply there. And Judge Federico, the other statute of limitations argument is the ongoing violations doctrine. We would argue there's a prolonged violation of her rights because she still cannot see her children. Her parental rights, a fundamental right, are still terminated until her daughters reach the age of 18. And there are multiple cases, Haven Realty Corp., Heck v. Humphrey, Zenith Radio Corporation, which all speak to the ongoing violations doctrine.
But do they do so in this context?
Your Honor, they're not specifically child custody cases, but some of them are 1983 actions, which we have here, and some of them all talk about the prolonged violation of fundamental constitutional rights, which is a similarity here.
Right, so you also argued equitable tolling.
Yes, Your Honor.
My understanding from the briefing is that, equitable tolling is something we see in a lot of habeas cases, but in this context, the Colorado Supreme Court has never recognized a case where equitable tolling would apply. Is that right?
Your Honor, I think you may be right about the Colorado Supreme Court. However, the federal courts have recognized, including this court, that equitable tolling is appropriate, specifically when the defendant actively misled the plaintiff, which happened here, when the plaintiff was prevented from asserting their rights in some extraordinary way. And we would argue that's also present here. And it's specifically the prong of equitable tolling where defendants wrongfully prevented someone from timely filing. If you look at the record, we've detailed a lot of reasons for that, specifically that defendants sought to prevent our client's attorneys from accessing her record. My co-counsel was actually objected to getting her record during the time when she was in jail. And the defendants also specifically sought a gag order against her, which wouldn't even let her call a friend to help her get an attorney in court. So there are a lot of circumstances that we detail in the briefs that prevented her wrongfully from filing. So we think that is a specific reason equitable tolling should apply. Our position would be the statute of limitations didn't begin to accrue. If this court disagrees, we would say equitable tolling should apply instead.
Counsel, before you move on, can I just follow up with my colleague's question about the Rooker-Feldman doctrine? Are you taking the position that you are not asking us to set aside the state court decision?
Justice Hyde, thank you. Yes, that's the position we're taking. We are not asking you to set aside the state court decision. Instead, we're asking you to provide another avenue in state court for our client to appeal the termination of parental rights. If the statute 193612 were to apply to her, she would be allowed to appeal the termination of her rights, even though that 21-day time period has passed. And in fact, many parents in other circumstances are allowed to appeal on that statute well beyond the 21 days.
Oh, okay. Help me understand then what you are specifically seeking.
Yes, Your Honor.
What's unconstitutional and what would get you an alternate remedy in state court?
Thank you, Justice Hyde. We would argue specifically that a combination of saying the 21-day appeal time period and the lack of
The
application.
21-day appeal period is unconstitutional.
Because 193612 doesn't apply to her. And most parents are given the exception of 193612. The only way this would ever apply to her is if her ex-husband were to pass away. Otherwise, when parents' rights are taken away for other reasons, say drug abuse, physical abuse, actual neglect of a child, they can still appeal to get their children back 3 years or more after the fact. But because her rights were terminated on the basis of a debunked and unconstitutional theory that the state of Colorado actually now bans, she cannot use this remedy to appeal in state court. So
Okay, but I guess back to what specific ruling would you want from us that the entire system is unconstitutional? What specifically do you want us to say is unconstitutional?
Yes, Justice Hyde. I think it could be more narrow than that. I think specifically finding that when a parent's rights were terminated based on the debunked and unconstitutional theory of parental alienation, this remedy of 193612 should be applied to them. And they should be allowed to meet the same standards. The child has to also want to reconcile with a parent. There's a trial period. There are some safeguards in place. But that a parent whose rights were taken away based on parental termination should also be allowed to use this remedy past the 3-year period since their rights were terminated on an unconstitutional basis.
Counsel, how do I square your response that you're not asking us to weigh in on the parental rights termination with your prayer for relief? You're asking us to reverse and remand this back to the district court, but you mean your prayer for relief specifically, number 1 says reverse the termination of plaintiff's parental rights and order a new hearing so plaintiff may appeal. So how do I square that with your response to Judge Ide?
Thank you, Judge Federico. We asked for multiple things in our prayer for relief. And I do believe that if this court were to agree that the theory of parental alienation was unconstitutional and a lack of procedural due process, the state legislature, in its legislative intent, actually wrote that there's very little evidence ever used in cases which violates Sankowski versus Kraber, which has clear and convincing standard of evidence has to be used to terminate someone's parental rights. So if you found that the theory of parental alienation was unconstitutional, that wouldn't directly overturn the state court decision, but in effect, it would make her termination unlawful.
Is there any reason why, after these adverse rulings by the state courts, you could not have sought a petition for certiorari from the U.S. Supreme Court to say that what happened in state court violated your constitutional rights?
Judge Hartz, I believe we thought going this route was the most beneficial to our client. The defendants multiple times threatened her attorneys, had a different attorney she had threatened them so much that they actually withdrew from her case. So we're pro bono working on her case, and we believe that this was the best avenue.
Can I just jump in there? I'm sorry, you have little time, so can you address your 11th Amendment argument?
Yes, Justice Ed. We believe that we specifically have an exception to the 11th Amendment immunity because we are suing a state official, Director Barnes, and an official from the county, Director Dossie, who, according to the county, stands as an arm of the state in their official capacities. That's an exception, to, as you know, to the 11th Amendment immunity is when we're suing state officials in their official capacity and seeking prospective injunctive relief and declaratory relief under Ex parte v. Young. And so because her rights are still being violated right now, we're not seeking to remedy a past situation, but instead to stop the ongoing prolonged violation of her rights through injunctive and declaratory relief. If she were allowed to appeal under 163912, she would be able to fix her situation. Also, if the theory of parental alienation were considered unconstitutional, that would also be a declaratory remedy.
Thank you.
Thank you. Time has expired.
Thank you, Your Honor.
Mr. Carty, I understand you want to split time, which almost never works well, but are you dividing it up by what issues you
We are.
really- Okay.
We are dividing it up by issues.
So should we give you 10 minutes, 5 minutes, 7.5 minutes?
I'm shooting for 10,
Okay.
so.
See how it works.
May it please the court, Deputy County Attorney Ryder Mott, on behalf of defendants, appellees, Arapahoe County, the Arapahoe County Department of Human Services, and Michelle Dossie. With me at council table is Jennifer Carty of the Colorado Attorney General's Office, who represents Michelle Barnes. This court should affirm the district court's dismissal of KA's complaint for 4 primary reasons. First, all of plaintiff's claims are barred by 11th Amendment immunity, where only official capacity claims have been asserted. Second, on statute of limitations grounds, where plaintiff failed to timely assert her claims and has failed to meet the requirements for entitlement to equitable tolling. Third, on Rooker-Feldman grounds, where all of plaintiff's injuries stem from state court orders, and she asked the federal court to overturn those orders and restore her parental rights. And fourth, on the issue of standing, which my colleague, Ms. Carty, will address. I'd like to start by discussing the issue of 11th Amendment immunity. Plaintiff has never meaningfully responded to this argument. Instead, both before the district court and again in her opening brief and in her reply brief, plaintiff argued qualified immunity, a defense that was never raised by the defendants, who are sued only in their official capacity. Thus, plaintiff has not provided any basis why either the Arapahoe County Department of Human Services or the Colorado Department of Human Services are not arms of the state and not entitled to 11th Amendment immunity, and it is plaintiff's burden to establish jurisdiction. The only argument plaintiff makes for avoiding 11th Amendment immunity is to argue the immunity would not bar her declaratory or injunctive claims. The exception to 11th Amendment immunity for injunctive relief under Ex parte Young, however, only applies to claims for prospective relief, not to redress past harms. Here, where plaintiff admits in her complaint at paragraph 111 and paragraph 115 of her proposed amended complaint that her DNN case is closed and final, she cannot establish any likelihood of continuing harm or ongoing actions on behalf of the department or the state.
She seeks to declare declarations that certain state laws are unconstitutional, does she not?
Well, I'd like to address that. That's a good point, Your Honor. The one state law that she seeks to challenge is a statute. It's 19-3-612 of the Colorado Revised Statutes, and that statute specifically has no applicability to plaintiff. Because that statute only addresses a situation. It was a statute written by the Colorado legislature to address situations where children linger in the custody of the Department of Human Services after parental rights are terminated. It has no application to the situation plaintiff is in where the other spouse is given custody of the children.
Not an 11th Amendment argument that you're making there.
I understand that's not an 11th Amendment argument
So
I'm
to the
making.
extent she seeks declarations that certain laws or practices are unconstitutional going forward, there's not an 11th Amendment problem with that, is there?
There's not an 11th Amendment problem. There's another problem, and the problem is that statute has no application to her. And what she asked this court to do is to rewrite the statute and create a new remedy that would apply to situations where a child is given custody of the children are given to another parent or a child is adopted. In those circumstances, to apply this remedy, which under state law only applies when children remain in the custody of Human Services and linger in the custody of Human Services after termination hearing. And so, again, this court doesn't have the authority to create new remedies under Colorado law or to rewrite the law as plaintiff would like it to be. Simply, seeking a declaration that this statute, which has no application to her, should apply to her, really isn't the role of this court. And so I don't think there's a basis for that.
Go ahead.
So with that in mind, because the defendants are entitled to 11th Amendment immunity, I do not believe this court has to decide the issue of statute of limitations, but if the court does, the statute of limitations too would bar plaintiff's claims. There's no dispute that plaintiff did not timely file her claims within the 2-year statute of limitations, which would have started to accrue with respect to her familial association claims when the department took custody of her children on February 22nd, 2019, or no later than August 25th, 2020, when the department terminated her parental rights. The same is true with respect to her challenges with respect to the protective order, and the subsequent contempt citations, which would have started to accrue in May 2020 when the first motion for contempt was filed. Here, plaintiff waited until June 20th, 2023 to file her complaint, well outside the 2-year statute of limitations for asserting claims in Colorado, Section 1983 claims in Colorado. Thus, given that plaintiff didn't timely file her claims, her statute of limitation defense turns on the question of whether she's entitled to equitable and tolling. It's important to note, however, that a district court's refusal to apply equitable tolling is reviewed under an abuse of discretion standard, not under the more forgiving de novo standard. Here, there's ample evidence in the record the district court pointed to that shows that plaintiff was aware of her claims and failed to act diligently in bringing them, supporting the district court's decision. Equitable tolling, which is determined in reference to state law, is allowed in 2 circumstances in Colorado. First, in cases of truly extraordinary circumstances, and the second is where defendants prevented plaintiff from filing her case. Plaintiff cannot satisfy either of those tests. With respect to the extraordinary circumstances test, plaintiff claimed she was incarcerated and lacked access to her records during COVID, meaning she could not timely file her lawsuit. But despite her incarceration, during this same period of time, the record shows that her attorneys were bringing similar constitutional claims and litigating them in state court, foreclosing her ability to say she could not have brought these claims. The first example of this, which was relied upon by the district court, was plaintiff's attorney, the same attorney who's representing her in this action, filed a habeas petition on May 20th, 2021, raising similar First, 8th, and 14th Amendment issues, the same constitutional claims she's asserting in this case. So both plaintiff and plaintiff's counsel were aware of these constitutional claims and still failed to file suit, waiting more than 2 years after filing the habeas petition to bring this action.
But doesn't plaintiff also allege that she was effectively denied access to counsel on this issue and that she was denied access to the record of the proceeding that would be needed for her to file a complaint?
Well, I think that that's belied by the record, again, because her attorney was raising these same issues, and these same constitutional claims during this time period through the habeas petition. The other example of that is found in the Court of Appeals decision on plaintiff's challenge to her third and fourth contempt citations. And in that decision, on page 238 and 239 of Appellate's appendix, the Colorado Court of Appeals notes that in September 2020, plaintiff's counsel filed Rule 59 motions challenging the constitutionality of the protective order, which is more evidence that they were aware of these issues. And the Court of Appeals, in that same opinion on page 248 of the appellate appendix, made a specific finding that KA was aware in December 20th because she discussed with her friends the possibility of hiring a First Amendment expert and appealing the protection orders. She just did not seek that remedy. So these documents in the record show that both plaintiff and plaintiff's counsel were aware of these issues and failed to timely act.
Is that discussion with friends the one that she was held in contempt for engaging in?
I am not positive on that, Your Honor. I do know, though, even more crucially, I think, to this claim about extraordinary circumstances, however, is the fact that plaintiff was incarcerated for less than 10 months, from a period of time of August 30th, 2020 through June 12th, 2021, and that's found at paragraph 75 of the complaint. The reason that's important is even if this court found extraordinary circumstances and decided to toll the statute of limitations for the entire period plaintiff was incarcerated, she still waited more than 2 years after being released from the jail to file her claim, which shows that she wasn't acting diligently, which is a requirement for the extraordinary circumstances test under the Lame Bowl decision of the 10th Circuit, July 26, 2022. Similarly, plaintiff cannot establish that defendants prevented her from filing her lawsuit. Plaintiff's argument is that defendants hid evidence of their actions, and she did not learn about the basis of her action until she was contacted by a former county caseworker, Robin Nicetta. However, as found by the district court, and that discussion with Ms. Nicetta happened after she filed this lawsuit. But as found by the district court, plaintiff, after obtaining the Nicetta affidavit, filed a complaint that included all of the same claims she had previously filed. So the district court found, and I found correctly, that it doesn't show that plaintiff was unaware of the basis for her claims. In fact, we know she was aware of the basis for her claims based on the earlier 2020 and 2021 Rule 59 motions and habeas petition. So there's nothing that plaintiff can point to that shows the defendants prevented her from being able to timely file her lawsuit in this case.
Counsel, can I just stop you there and ask, what do you think the order of decision is here? I guess you've said the 11th Amendment. If we find that you prevail on the 11th Amendment, then we're done, correct?
I believe you're done. I mean, I think the court could go in any order because I think if the court decided the statute of limitations in our favor.
Well, is that a jurisdictional issue, statute of limitations?
I mean, I believe it is at this point when it's established that it wasn't timely filed based on the allegations in the complaint.
And where does Rooker-Feldman fit in there?
And again, I think this court could start with Rooker-Feldman and decide on Rooker-Feldman that her claims are barred jurisdictionally because, again, all of her claims stem from these state court orders.
How about as between the 11th Amendment and Rooker-Feldman?
I mean, again, I think
you think we could start anywhere?
You could start on any of those issues, and I think we clearly win on any of those procedural grounds, jurisdictional grounds. So,
thank you.
You've got less than 4 minutes left.
Yeah, real quickly, and then I'll turn it over. Simply put, plaintiff is asking this court for a do-over by seeking to collaterally attack all of the state DNN orders through this federal lawsuit and asking this court to restore her parental rights. Federal courts, however, lack jurisdiction to issue domestic orders or to sit as super appellate courts in reviewing state court decisions. Plaintiffs have had a lot of process and opportunities to make these arguments in state court and failed to timely or successfully do so. Thus, this court lacks jurisdiction to issue the relief requested by plaintiff, and thus dismissal of her complaint should be affirmed. And at this point, I'll turn over the rest of my time to Ms. Carty.
May it please the court, Jennifer Carty on behalf of Director Barnes.
Plaintiff fails to demonstrate standing to bring suit against Director Barnes in her official capacity for 3 reasons. 1, she fails to identify a state statute with which the State Department has a connection of enforcing that's tied to her injuries. 2, she fails to plead sufficient facts to establish a state-enforced custom or usage. And 3, because of those 2 things, there is nothing for this court to enjoin. As this court knows, to establish standing, the plaintiff must plead sufficient facts that the government entity is the moving force behind her injury, and she has to show that this court has the ability to redress her injuries. She has not done so here. She has not established a meaningful nexus. To the extent she alleges an informal custom of parental alienation, the facts that she's pled do not support an inference that there exists a widespread, persistent, and well-settled custom across the 64 counties that the State Department is responsible for supervising. She identifies a single case in a single county. She also alleges a conclusory statement that the county attorney that acted in her case uses this parental alienation theory to terminate the rights of mothers. But conclusory statements and pointing to a single case is insufficient under the case law to demonstrate a widespread settled practice by the State Department. To the extent that plaintiff argues that House Bill 231178 shows that the State Department has this custom, you'll note that this legislation cites to Title 14. Title 14 is domestic relations. This concerns parental allocation proceedings for every divorce case in the state of Colorado that allocates parental rights when children are involved. This does not involve Title 19 or the department as a party.
Counsel, do you agree with your co-counsel about sort of whether we need to reach standing if we were to decide this on other grounds such as statute of limitations?
Your Honor, I would agree with my co-counsel that any of these bases would satisfy grounds on which we would prevail. I actually don't think that standing should be the primary. I think 11th Amendment or statute of limitations is appropriate.
But we don't have jurisdiction to address statute of limitations. If we don't have jurisdiction to address issues, we can't.
Yes, then 11th Amendment immunity would be the primary and then standing the secondary. In her appeal brief, she cites only to another statute, 193308, Section 4A, which was not raised in the briefing below, and it was waived. She also refers to Title 19 generally. This lacks specificity, provides no notice to this court or the department as to what she's seeking to enjoin. But I will say that Title 19 includes responsibilities for various other agencies and the State Department, including the Office of the Child Protection Ombudsman, the State Registrar of Vital Statistics, and the Department of Public Health and the Environment. The ex parte Young exception to sovereign immunity permits only prospective relief, and the relief that the plaintiff has requested is not something that can be granted.
You know your time has expired.
I do, Your Honor, and if this court has no further questions, we would just request that the court affirm the rulings of the lower court.
Thank you, Counsel. Did the appellant have some more time? Can't remember. No? Okay. Thank you, counsel. Case is submitted. Counselor excused. We're going to take a brief break before we take up the next 2 oral arguments.
Court is in recess. I'll go first. The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Please be seated. Start now with Rio Grande Foundation versus Oliver, 24-2070. Mr. Schwab.
Good morning, Your Honors, and may it please the Court. I'm Jeffrey Schwab, and I represent plaintiff appellant, the Rio Grande Foundation. The provision in New Mexico's Campaign Reporting Act requiring donor disclosure of ads that mention but do not expressly or implicitly advocate for or against a candidate or ballot question violates the First Amendment on its face. 3 points support this conclusion. First, the Rio Grande Foundation's speech, which simply mentions candidates but does not expressly or implicitly advocate for or against their election, is not for the purpose of influencing the outcome of an election. And the district court's conclusion that speech that refers to a candidate or ballot question without expressly or implicitly advocating for or against them could still be published for the purpose of supporting or opposing a candidate or ballot question is wrong.
Well, let me ask you about let's start with what the statute says, because that's going to be important to the analysis. So we're talking about disclosures of independent expenditures, right?
Correct, Your Honor.
And an independent expenditure has to be an expenditure. Is that correct?
That's correct, Your Honor.
And an expenditure is something that's a payment incurred in an election, let's see, or other thing of value, I should just read the language, but it ends with, for a political purpose. It has to be made for a political purpose.
That's correct.
And political purpose means for the purpose of support or opposing a ballot question or the nomination or election of a candidate. So you agreed that to be an independent expenditure, by statutory definition, it has to be for the purpose of supporting, in this context, the nomination or election of a candidate, supporting or opposing.
Correct.
You agree with that?
I agree with that, yes.
The provision you're talking about now is 3C.
That's right.
And you say, because 3C is obviously in addition to the requirements in 3A and 3B, it's got to be something different.
That's right, yes.
And here's where I don't understand your point. 3B says if it's an expenditure that is made to pay for an advertisement that is susceptible of no other reasonable interpretation than as an appeal to vote for or against a clearly identified candidate. Therefore, C could include something where there's a reasonable interpretation that it's to support a candidate, but it's not the only reasonable interpretation. And you seem to say it's got to be an expenditure that could not reasonably be interpreted as supporting or opposing a candidate. But I think there's a broad area in between where it could be reasonably interpreted one way or reasonably interpreted the other way.
I don't think that's correct, Your Honor. I think A applies to express advocacy that everybody would know is advocacy because it has the magic words or it's pretty clear. I think B is something that is not so clear, but a reasonable person would understand it as advocacy.
It says there's no other interpretation of this expenditure except as being to support a candidate.
I don't think it's that clear. I think it's susceptible to no other reasonable interpretation. Right. Reasonable interpretation. So
the only interpretation you could make, the only reasonable interpretation would be that it's to support a candidate. So if there's a possibility of a reasonable interpretation that it's not to support a candidate, and also a reasonable interpretation that it is to support a candidate, then it's not covered by 3B, and 3C would include that.
I still don't think that's true. I think if there's any reasonable interpretation that it is support or in opposition to a candidate or ballot question, it would be covered by B. Because B follows the language of Citizens United. In Citizens United, they use this same susceptible to no other reasonable interpretation language, and they also sometimes call it the functional equivalent of express advocacy. I call it implicit advocacy. I think those are all the same things. So I think that A covers express, B covers implicit, or something that.
I have a hard time reading B the way you do, but if the Supreme Court in Citizens United interpreted this exact same language the way you did, that would be pretty persuasive to me. But I don't, and it makes a difference in how your argument goes, whether C could include contributions or an ad that could be interpreted as supporting a candidate, but may not. For example, the sort of ads that Rio Grande produces that just rates candidates and doesn't say whether that's good or bad necessarily. Well, I guess it probably says it's bad, but someone who gets a low rating from Rio Grande might run for office saying, hey, look, I'm great. I oppose everything that this organization supports.
I don't think Rio Grande Foundation's speech would be covered by B, and I don't think it's also reasonably to interpret it as any kind of advocacy for or against the candidate for a couple of reasons. One is just pointing to the Freedom Index. I think there's a link in the appellee brief. If you haven't looked at it, I'd encourage you to look at it. But on their website, the Freedom Index, all it does is a legislative scorecard of pieces of legislation based on, I think there's 12 indices of things that Rio Grande Foundation finds important. There's things like government size, taxes, constitutional provisions, equal protection, things like that. And then for each piece of legislation, they give a yes or no vote, a score somewhere between -8 and +8, depending on what number of issues are involved in that legislation. And then they total up the number of
But
score.
a high score
Right, but
would tell people on the Rio Grande mailing list that this is someone you should support if you like what we do.
But
Would it not?
But the Freedom Index doesn't say anything about
Right.
the candidacy. It doesn't say anything about go vote for this person.
Well, but
It
it's
doesn't-
not subtle about it. I mean, if you just looked at it and it just had the scores, maybe. But it also happens to be color-coded in a way that, again, green, wouldn't a member of the public say, well, this person got a score that's green. Therefore, under Rio Grande Foundation's view, green means go. I should vote for that person. Isn't that obvious?
No, because the green is because the scores are +8 to -8, the green is just plus and the red is negative. So it doesn't say +5 or -5. It says 5 in green or 5 in red. So I don't think that it's a subtle, these are good people, these are bad people. It's just, this is the score, and if it's green, it's plus, if it's negative, it's not.
I'm kind of where Judge Federico is, that I think people would take that as a support, but say no reasonable person could interpret this ad, this publication by Rio Grande, as endorsing candidates. Then wouldn't it be very hard to show that it was made for a political purpose and therefore would not be an independent expenditure that has to be disclosed under the New Mexico statute?
Well, first of all, there is, the parties agree that if Rio Grande were to spend the requisite money that under C, they would be required to do that. I think that there is a decent argument that because it has to be for a political purpose, that Section C ads that aren't for a political purpose shouldn't be covered by.
Well, yeah.
And that's what I argued before the district court, and the district court disagreed with me. I said that Section C was in conflict with the definition of political purpose. The district court disagreed with our argument on that. and said that, no, it can be for a political purpose under C, even if it
Do we
doesn't.
defer to the district court on how to interpret the statute? I don't think we have any deference required in that respect, do we?
I don't think so. I hope not.
Okay, so if it's not for the purpose of supporting or opposing a candidate, it's not an independent expenditure, period. Isn't that correct?
Yes, but if
So
that's.
and I would find it hard to find that something was for a political purpose, an ad was for a political purpose, if there's no possible reasonable interpretation that this is to support a candidate.
I think I agree with you, and I think that's sort of my point, is that that these ads.
For statutory, that's a statutory argument, it has nothing to do with your constitutional arguments. But I think, well, I shouldn't say it has nothing to do with it. You might prevail on a statutory ground, and I think you might. But you're saying that even if it's banned by the statute, you have constitutional arguments.
Well, if it is banned by the statute, then I think we have a constitutional argument. But if it's not for a political purpose, then I don't think it applies. But the defendant says that it applies to us. So Rio Grande Foundation's speech is chilled either way, because they're not going to spend the money to put these ads when they think that they're going to be subject to the statute. And so they have to bring it before this court so that they can speak without having to worry about being subject to the statute. And if the statute doesn't apply to them, then I think that there should be an order from this court explaining that speech that is not for a political purpose is not covered by the independent
I'm just
expenditure.
looking at the definition. Let me get to the constitutional issue. I didn't expect to spend as much time in the preliminary part, but as I read Citizens United, purpose is not necessary to have a constitutional disclosure requirement. In Citizens United, I'm paraphrasing, and you can correct me if I'm misparaphrasing. I thought the one rationale for allowing expenditure disclosures, independent expenditure disclosures, was that the public has a right to know who's saying something about a candidate in the time just before the election. It had nothing to do with whether the person is saying something about the candidate for a political purpose. It said that, and that, as I read Citizens United, was the only rationale given to support the constitutionality of the disclosure requirement. And am I misreading Citizens United?
I think maybe reading into it, I would say, because Citizens United dealt with an as-applied challenge to a specific ad. The ad was for Hillary the movie. And the Supreme Court in Citizens United said that it was very clear that that ad was pejorative against Senator Clinton's campaign for president. And so in that case, I think if it was, say, subject to New Mexico's statute, it would fit into that Section B because it's susceptible to no other reasonable interpretation.
The Supreme Court could have said, in finding the application of the statute constitutional in that case, that the public has a right to know about anyone who's expressing support or opposition to a candidate in the brief time before the election. But it didn't. And we take their dicta really seriously in the lower courts. And it sure seems to me that it's saying this statute is constitutional because it has the proper purpose of educating the public about what is said about a candidate in the short time before the election. And that would seem to foreclose your arguments. Tell me what I'm missing here.
I think there's a few reasons. One is the Supreme Court in Citizens United, when they address disclaimer and disclosure requirements, they address the disclaimer requirements first. And the argument that they made for why the disclaimer requirements were constitutional was because they said that the voters had a right to know the arguments being made about the candidate or whoever. And applying that to the disclosure requirements, if it's not an appeal to support or oppose a candidate, there's not an argument being made to the voters. So that rationale doesn't apply. A couple of other reasons that Citizens United is distinguishable. One is both Citizens United and this court's decision in Independence Institute. I see my time's up. Should I finish my point?
Please.
Both of those cases were decided before the Supreme Court's decision in Americans for Prosperity versus Bonta. In that case, the Supreme Court added a narrow tailoring requirement to the exacting scrutiny. Neither Citizens United nor Independence Institute applied the narrow tailoring analysis. And I think in this case, applying the narrow tailoring analysis makes a difference, because if you remove section C3 from the act, you still can achieve the government's informational interest, because it will cover express and implied ads that are seeking to support or oppose a candidate, and that covers what the government's interest is. I'll stop if the...
Well, actually, don't stop. Let me just ask you, so I don't think you've ever gotten your actual argument on the constitutionality out. So maybe let me try. So A is express advocacy, B is implicit advocacy, and that's all that you can regulate under the Constitution. Is that what you're arguing?
In this context, yes, because it doesn't support the government's interest under the exacting scrutiny analysis, because section C3 adds just the way that the statute is structured is different from the way that the statutes in Citizens United and Independence Institute were structured. In this case, in Independence Institute, this court said that it was difficult to find a principle to distinguish between speech that's essentially express or implied advocacy and that's not. In this case, the statute actually does that work for you, because it sets forth 3 categories of speech, 2 of which are express or implied, and the third of which is just speech that mentions a candidate. In Independence Institute, in those statutes, they didn't do that. They just applied to what they called electioneering communications, and that just, there was no distinction between express or implied advocacy. And so I think that makes a difference. It is also notable that in both of those cases, those electioneering communications didn't apply just to independent expenditures. They applied to any communications, well, not any communications, because there are a limit on the communications, but all communications, regardless of who they were made by. And I think that makes a difference, because if it's an ad that just mentions a candidate, but it's either coordinated with a campaign or by a campaign, I think there it makes sense to say that that is actually maybe implied advocacy, because it's from a candidate who might be opposed or in support of another candidate. Whereas here they're just independent expenditures, so they're not coordinated with a candidate or campaign, and they're not by a candidate or campaign. So it's just a third party speaking who happens to mention a candidate. So I think that makes a distinction between this case and those 2 cases as well.
Thank you.
Yeah, this is important, so go ahead.
Thank you. 2 what I think may be housekeeping questions. One is, you mentioned exacting scrutiny, I think twice here today. Your brief, you argued we should apply strict scrutiny. I think you said just to preserve that argument. So do you agree that Supreme Court precedent, including Bonta, requires that we apply exacting scrutiny here?
I do agree, but I think the Supreme Court should apply strict scrutiny. Because
take that up with them.
I will, but I will say that's because the Supreme Court says that political speech is the most important speech, and also in Reed versus Town of Gilbert, it said that content-based restrictions on speech are per se unconstitutional. And in that case, it was a sign, and it treated political speech, the political signs, more favorably than a directional sign. It's very weird to say that if it was the opposite, that would not have gotten strict scrutiny. If it treated a directional sign more favorably than a political sign, that it should not get strict scrutiny. And that's essentially what we're saying here. I think that's strange. So I do preserve that argument for the Supreme Court.
Understood. And second question is, because this is a facial challenge, who has the burden here?
Well, I think we have the burden, but I think that it's pretty clear that all of the, in fact, the reason that this is different than Citizens United and Independence Institute is because the statute differentiates between these three categories of speech. Every instance of the speech in Section C3 will not actually either be express or implicit advocacy. So they're all just mentioning a candidate or ballot question, but not advocating for or against them, either expressly or implicitly. So there, I think it makes it easier to show that in all of the iterations of that speech, that it would be unconstitutional.
Thank you, counsel.
Thank you.
Ms. Venegas?
May it please the court, my name is Ellen Venegas on behalf of the New Mexico Secretary of State, Maggie Toulouse Oliver. This case is about whether a special interest group can override the state of New Mexico's efforts at election transparency. Specifically, the case involves the state's requirements for limited disclosure for funding sources of political advertisements, which the statute at issue refers to as independent expenditures. RGF has chosen to bring a facial challenge to the disclosure regime, taking part with one definition of the independent expenditure section, and I think that definition bears repeating in full here. It applies to an advertisement that refers to a clearly identified candidate or ballot question and is published and disseminated to the relevant electorate in New Mexico within 30 days before the primary election or 60 days before the general election, at which the candidate or ballot question is on the ballot. Now, the Supreme Court recently reiterated that facial challenges, even in the First Amendment context, are hard to win. And RGF doesn't meet its heavy burden to show there are any unconstitutional applications of the statute here that would outweigh the constitutional applications. In fact, on this record, RGF hasn't shown that there are any unconstitutional applications of the statute because its arguments are premised on asking the court to draw a line that courts have consistently refused to draw.
Can we start again with what the statute means? Because apparently the district court read the statute differently from what I think it clearly says, and apparently the district court interpreted the way you do. So I want to understand if you read the statute, understand how you read the statute. So to be an independent expenditure, it has to have a political purpose. Do you agree with that?
Correct.
So it has to be for the purpose or support of, in this context, the nomination or election of a candidate. You agree it has to be?
Yes, the expenditure, yes.
How do you read 3B? I read it as saying that the advertisement that has to be disclosed can only be interpreted as appealing to vote for or against a candidate. Not that it could reasonably, if there are reasonable, if you could reasonably read the advertisement both ways, for example, what probably would be the case for what Rio Grande wants to do, which is just lists candidates and gives them a rating. Do you think it comes under 3B?
Your Honor, I don't think, first of all, I do read 3B how you are, that it has no other reasonable interpretation other than an appeal to vote. And I think The Freedom Index highlights why the temporal components in Section 3C are so important here. If I were to receive a copy of the Freedom Index in the mail 6 months before an election, I might not view the only reasonable interpretation as an appeal to vote. I think that answer could change within the temporal limitations identified in Section 3C. And I think that is a good example of why the categories, they're not as as exclusive as RGF contends. And given the temporal aspects of Section 3C, a communication could be interpreted differently closer in time to the election.
Now, I read your response to say the Freedom Index fell under 3B. Is that right?
I believe the parties agreed below that the Freedom Index fell under 3C.
Okay, so.
And again, Your Honor, I think maybe at some points in time it would fall under 3B, but at any given time, I don't believe it would always fall under 3B.
So it's not the green and the red, go versus stop, vote for this person, go, and stop, don't vote for this person. It's the timing element that may put it between B and C?
I think it's a combination of things. Individuals look at communications differently that they receive in the mail and evaluate them differently depending on whether there's an election in the near future. So even with the rating, receiving that communication far away from an election, it may be viewed differently.
What if this Rio Grande Foundation sent out a mailer to New Mexican voters 30 days before an election that said, reminder, election day is this date. Here are the candidates running for this office, and that was all. They were sort of equally presented. Would that fall under the 3C and require disclosure?
Your Honor, there is an exemption under the advertisement definition in the statute that exempts things that qualify as nonpartisan voter guides. So if that qualified as a nonpartisan voting guide, then it would not fall
So I
under.
guess that's really what I think we're trying to get at is what is the distinction here? Because as Judge Hart's mentioned, one could read Citizens United, in our case, applying it an independent institute to say it's not required that it have a political purpose because the state has an interest within a certain time frame of requiring disclosure of who's funding any communications about candidates. First of all, do you agree with that premise?
That the ad doesn't need to have a political purpose, or?
Not under the statute, but we could read Citizens United that way.
Correct.
Okay, and so the statute seems to do more than perhaps is required. And so ads like this that may fit into another exemption in another part of the statute, just trying to figure out sort of where the boundaries are. Like what work does 3C do at all is what I'm trying to figure out.
Sure. I think 3C serves to capture communications that are not so express as to amount to express advocacy, but are more subtle in their messaging and could contain a level of implied advocacy. And I think with RGF's argument, they're sort of downplaying the informational interest that the state has in the information that is important to voters to assess. So for example, if a voter was sent a communication that spoke favorably about a new ballot measure or just said this ballot measure will help our community, something broad like that, but didn't expressly advocate voting yes or no on the ballot measure, a voter still has an interest in knowing who funds that because it could be that all of the funding is coming from out of state, or it could be that a majority of the funding is coming from a corporation that might be benefiting from the tax. That kind of information is helpful in evaluating the message.
I'm going to challenge that. I think the Supreme Court has said otherwise. Would you say that's helpful? But all it does is mean we're making ad hominem arguments, which is what everybody does in politics these days. Do you think that's really so helpful? Don't you think it'd be good if we actually addressed issues instead of who's supporting it?
I think both are important, Your Honor, and I agree. If we could just really stick to the issues, that would really be an ideal situation. But unfortunately, that's...
But that's the voters' only interest in knowing who's paying for this ad, is ad hominem analysis.
The Supreme Court and other courts have also...
I'm agreeing with you. I'm not... no one seems to agree with me on this point, but I just thought I'd raise that. If you're going to say that's a good reason, I wanted to challenge that.
Okay, understood, Your Honor. Yes, I think the courts have recognized sort of a value to voters in what weight to place on the message, and some of that does come from knowing who's behind the message, which could conceivably distract from the issues. But here,
Well, I'm sorry, if the contours, though, of what is captured under 3C seem to me, from what you have presented here today, are somewhat unknown, then how is the CRA here distinguishable from the Wyoming law that we analyzed in Wyoming gun owners?
sure, well, I think we don't have an argument here, like in Wyoming gun owners, that the statute is vague. There's no vagueness challenge. There's no, when considering exacting scrutiny, we also have to examine the burdens of disclosure vis-a-vis the state's interest. And we don't have any arguments from RGF about the burden themselves, the disclosure requirements being unclear, onerous, or hard to understand. It's just an argument about what type of communications the state may lawfully regulate. In the Section 3 definition, it closely tracks the federal definition of electioneering communication and other states' disclosure laws as well. So I think regardless of...
It tracks, except for, the New Mexico statute requires a political purpose. These other statutes don't require that, isn't that correct?
That's true. The New Mexico statute requires that the expenditure be made for a political purpose, which doesn't necessarily require that the ad itself be assessed as to whether it has a political purpose. And I think, there could be some room for improvement with the wording of the statute, but the provisions can be read in harmony here. I think it's pretty clear what the legislature is intending to regulate by Section 3, given that it tracks the disclosure regimes of many other governments.
How did the district court interpret 3B? Opposing counsel suggested that the district court said if the advertisement could be reasonably interpreted as supporting or opposing a candidate, then it fits within 3B. Is that how the district court interpreted it?
I don't believe so, Your Honor. I believe the district court interpreted it as we proposed in our briefing, which is that 3B has to be so expressed that there's no other reasonable interpretation but as an appeal to vote. And then the district court found that there's some room there between no other reasonable interpretation and then a possible reasonable interpretation of advocacy.
Counsel, I'm sorry, you said something a moment ago that kind of tripped me up a little bit about there's no evaluation of the ads themselves, whether or not the disclosure is triggered. It's really the expenditure, so if it's made with the intent for a political purpose. But how is that ever determined? Maybe I just misheard you.
I was identifying that the statute itself requires that the expenditure be for a political purpose. So it's not the ad that is subject to a political purpose interpretation. And so our position would be that these provisions can be read in harmony and that listing the types of advertisements will be covered. The legislature is indicating what it sees as like when money spent would be spent for a political purpose by spending large amounts of money on those advertisements. And to the extent there is any conflict within the statute itself, I agree with Judge Hartz, what you had brought up, that this would be a statutory issue and not a First Amendment violation.
Well, I think I was saying how we interpret it.
Well, again,
It affects our constitutional analysis.
That's correct, Your Honor. But again, we don't have any argument here that the statute is vague or that it's RGF doesn't understand what's required of them. They just don't want to comply with the disclosure requirements.
Counsel, can I ask you to define what you think a state can regulate in terms of speech? What's the outer rim of your authority?
I think that The outer bounds would just be what is covered in our statute here, and it's very similar to what is commonly called electioneering communications. So it's something that mentions a candidate or ballot issue in the days before an election and is also disseminated to the relevant electorate.
So anything that mentions a candidate before an election, you can regulate. That's how you're defining it?
Almost anything. There are some exceptions which are listed in the definition of advertisement. And so, for instance, communications solely to the members of a group, those are exempted. Nonpartisan voter guides, as I mentioned before, there's a newspaper editorial exemption. So those types of things are not included in that.
When you say regulate, that's pretty broad. You're just talking about, I hope you're not endorsing regulation other than disclosure of funding.
No, Your Honor, sorry. I'm just, this case is limited to the disclosure requirements. So when I say regulate, I'm thinking about disclosure requirements.
I want that to be clear.
Counsel, same question I asked to Rio Grande about burdens. Do you agree with their response here? I mean, this is a facial challenge, which typically they would have the burden, but we're also talking about they've raised a constitutional challenge on this disclosure requirement. So how do you see the burdens here?
So the state has the burden to prove exacting scrutiny, but RGF does have the burden in this facial challenge. And that brings me to a point I wanted to raise about RGF's asserted burdens, which again don't talk about the actual disclosure requirements, but are based on, I see my time is up. They're based on the asserted chilled First Amendment rights. But when talking about burdens, even though we have a facial challenge, we're once again back in sort of as-applied territory, where all RGF has shown is one declaration about its own situation, and that declaration was from 2020. It's the same thing they showed for standing, and years later, we don't have any additional evidence to show any burden on RGF or any other groups in New Mexico.
Thank you, counsel.
Thank you.
I think Appellant, we even went over time, as I recall. So, case is submitted. Counsel are excused. Thank you. And we'll turn to our last oral argument of the day. And that case is 24-4039, North Brevard County Hospital District versus C.R.Bard.
Good morning, Your Honors. If it please the court, I'm Stephen Berry, representing Appellant, plaintiff, North Brevard County Hospital District, doing business as Parish Medical Center. Parish would show the court as follows. This court has jurisdiction to review the tying final judgment on the merits merged with class interlocutory findings prior to the, that is now before the court. Second, the district court erred in dismissing the tying claim by misinterpreting dictum in Abram and sports racing. This court has never created an enforcement gap by holding that purchasers suffering antitrust price injury by purchasing the monopolized tied product, here PICS, lack standing to assert a tying claim. Third, as to the jurisdictionally merged class interlocutory findings, the district court pervasively erred by failing to follow the Supreme Court and this court's unequivocal and well-established direction in Tyson's Foods, Black versus Occidental Petroleum, In Re, Urethane Antitrust, and Monacal. It's a trifecta plus one of error we believe respectfully submit. I note here that we contend that its typicality, adequacy of representation, and predominance findings should be reversed. And since the district court accepted Parrish's other prerequisite showings, to expedite resolution of this matter, first filed 5 years ago in 2020, with a told statute of limitations period now at 9 years, Parrish respectfully petitions that a mandate issue directing the district court to certify damage in injunctive classes so the parties may proceed to trial on the merits. Jurisdiction. This court has jurisdiction. Excuse me.
Let me try to understand your claims a little better. What, is there any difference in proof between your tying claim and your monopolization claim? Isn't your tying claim that because of the tied product, the defendant Bard has monopoly power, and that's causing the price of the catheters you want to be raised?
Yes.
How is that different from your monopoly claim?
It isn't.
It isn't.
And
So what's so terrible about saying you shouldn't be the one bringing the tying claim?
Because I can bring the
Because there's some better
monopolization.
people. Well, just go, it really amounts to a monopoly claim. It's kind of what I think our opinion in sports, whatever, was saying, that they're not the best person to bring the tying claim, but they have a monopoly claim. Wasn't that the same situation there?
Well, I would disagree. The talisman in antitrust canon across the board is if a party suffers direct antitrust price injury, it has standing, full stop. There's no enforcement gap that the court is manufacturing here by relying on dictum. This court has...
It's not an enforcement gap, is what you're saying, because you can proceed with your monopolization claim.
Well, it's a tying enforcement gap.
Okay.
I mean, it shouldn't depend on whether monopolization is on the four corners the same as time.
But it does mean that's really the essence of your claim, is the monopolization aspect. But you're not buying the tying product. I'm going to get that wrong in every question I ask. You don't want the tying product. And usually for a tying claim, and virtually every case that has a tying claim apparently has this situation, you don't want to spend the extra, you don't want to spend too much money on the tied product. That should be competitive. But to get the tying product, you have to buy the tied product. That's not precisely what your problem is. Your problem is that because other people are stuck that way, it gives monopoly power to Bard, and that's the gist of your claim, the monopoly power.
Yes. And in the relevant product market for PICS, there's monopoly power, and it's caused by the tie. And that sounds both in tying and monopolization. And for the court to find that tying is off the board, we believe is inappropriate. This court has never held that purchasers suffering antitrust price injury by purchasing the monopolized tied product, here PICS, lack standing to assert a tying claim. The court has never, all the district court did saying, by the way, I would decide this differently if I wasn't bound by sports racing and Abram dictum, which we consider as dictum. He didn't.
Yeah, but counsel, the Abraham decision was looking at, the direct purchasing rule based upon the definition of tying arrangements that came from the Supreme Court. And, so whether ultimately how the Supreme Court has defined this sort of tying arrangement as dictum, but that's binding on us. And I mean, couldn't a reasonable argument be made that Abraham, even if it, in applying that dictum, did establish this direct purchasing rule that, and you said a moment ago, the court is, or anyone who suffered antitrust injury has standing, full stop. But I mean, I don't think it's that clear. I mean, what we're talking about here is how to apply Abraham, and would you acknowledge at least the dictum doesn't go your way?
Well, Abraham doesn't get the district court where it wanted to be because it did not address the question of whether the purchaser of the tied product has standing. the plaintiff hadn't even bought the relevant tied product in Abram. So it can't be
Yeah, but
quoted
it expressed its
as part of the holding.
But it expressed its intention and its desire to do so, which is absent here. Isn't that the gap? In Abraham, the plaintiff said, well, we suffered injury because we want to purchase this tied product, but based upon the antitrust injuries we've been suffering, we would have to pay higher prices, therefore we have standing. Here, as I understand it, Parrish is saying, well, we don't want to buy the tied product. However, our injury is that the price of the product we do want to purchase has been elevated. So isn't this case easily distinguishable from Abraham in that regard?
Yes, it is. And therefore, this
But in a way that's not helpful for you, right?
Well, I think it is helpful. Therefore, this case should go forward. Because, and you can't say that there's stare decisis on Abraham on this point because it wasn't part of the holding. And it's basically the court, enough.
Well, let me, there are a lot of things in this case. You said that you should prevail on the tying claim because if you have an antitrust injury, you can proceed. But antitrust injury, as I understand it, maybe I got it wrong, doesn't mean that you're injured by antitrust activity. There's more to it than that. For example, when the wholesaler is the one directly damaged by the antitrust agreement, it's the wholesaler who can bring the claim, not the retailers who suffer injury, even from the antitrust.
That's Illinois Brick.
Yes. So there's this notion that you don't have an antitrust injury just because you're injured by antitrust activity. It's more than that, and in some sense at least, you don't have an antitrust injury unless you're a good person or the best person to bring the claim.
Well,
and here, I think the district court understood that to mean that people who buy both the tied product and the tying product are the best people to bring a tying claim. And that's really not so bad for you because you still have the exact same claim you're going to make, but you just do it under Section 2 instead of Section 1. What's wrong with that?
Well, what is wrong was that the court is basically pouring out of court in a tying context a party that has been injured by direct antitrust price injury due to monopoly power conferred by the tie. You're out of court, and there's no policy reason why that should be. And just referring to some loose language in dictum that there are two categories of claimants shouldn't end the analysis.
One difference between you and the people who buy both the tying and tied product is you could lose on your tying claim if you can't show monopoly power. And the others don't have to prove monopoly power to prevail on their tying claim. Isn't that correct?
No, you have to show that the tie confers monopoly power. You have monopoly power in the tying product.
You have to do that, but does a purchaser of the tying and tied product?
Yes.
Doesn't that person have a claim for a tying claim without showing that this tying practice of the defendant actually gives the tying defendant monopoly power? They don't have to prove that element.
I don't think that's the law. I think that
You think they have to prove tying?
you have to have monopoly power in the product that's being sued upon, whether it's the tying or tied product. And if there is monopoly power, there's direct antitrust injury. You'd have to show to get to injury that there was monopoly power or market power or whatever you want to call it. So I would respectfully disagree, Your Honor.
Probably right.
Let's
Counsel,
talk
can I
about.
ask you about your Section 2 claim? Help me understand your argument as to why Baker and Anderson Living Trust don't resolve this question.
Yes, because Anderson Living Trust is distinguishable on three important grounds. First, Anderson did not address the situations here where the interlocutory rulings are merged with a final judgment on a merits claim, here, tying. Second, unlike Anderson, Parish Hospital is not seeking to end run Rule 23F. In fact, Parrish made a timely petition under 23F.
So didn't that happen in the Microsoft case also? Hadn't they pursued 23F and were rejected? So then they manufactured jurisdiction.
Okay, well, yes, they were manufacturing jurisdiction, even though they had been denied on 23F, they were end running it. They had 2 bites of the apple, and the Supreme Court said, no, I'd like to reserve 3 minutes of my time.
You're going to have time to make your argument, okay?
Okay.
But I thought you said you pursued 23F in this case. You were denied.
What?
Yes, so then you manufactured jurisdiction just like they did in the Microsoft case.
Well, under the merger rule, we're not manufacturing jurisdiction. The interlocutory ruling was merged with the merits finding, final judgment on the tying. If I could address that for a moment. This merger distinction with Anderson is particularly salient. Under well-settled appellate tenets, litigants may, in the course of appealing a final decision, as here, challenge earlier interlocutory rulings. The merger foundation of this court's jurisdiction is seminal Supreme Court precedent as far back as 1891 in McLeish, 141 U.S. 665. As the court put it, quote, from the very foundation of our judicial system, the object and policy of acts of Congress have been to save the expense and delays of repeated appeals in the same suit and to have the whole matter in controversy in it decided in a single appeal. That's what we want here. Indeed, the Supreme Court in Baker cited McLeish in haec verba for that proposition. So it could be argued that case supports our distinction here that Livingston Trust does not apply, nor does Microsoft v. Baker to deny interlocutory consideration under the merger rule of class rulings. In fact, we believe this court would more likely or more beneficially look to its precedent in Crowley Petroleum, which was authored by Your Honor, Judge Hart, and Schmurier, in which Judge Hart was on the panel in that case. In Crowley Petroleum, Your Honor, Judge Hart, found for the court an order.
You're losing the other 2 judges every time you cite me, so be careful about that.
Well, yes, Your Honor, I would be very careful about that. Where the court found that an order voluntarily dismissing a class action was a final decision which fully resolved the matter before the court and was appealable. And that was in 2021, some years after Anderson Living Trust. In Schmier, the court found that dismissal of class claims with prejudice creates finality if there were prior claims adversely dismissed with prejudice. That's what's here. Prior claims adversely dismissed with prejudice, then there's finality, and you can deal with the class rulings.
You're going to be able to address all of them, but not with unlimited time. So why don't you turn to one of your other issues that you don't feel you got a chance to argue?
All right, the class issues. Should the court assert jurisdiction?
That's it then?
Yeah,
You're out of time, but go ahead and briefly address.
I will be brief.
Issues. Yeah. Our argument is to help us, and if we think we're still being helped, you're going to be able to talk. Okay?
Well, I'm glad. Hopefully I am helping, Your Honor. Under well-established Supreme Court precedent, Tyson Foods recently relied upon in this circuit in Black versus Occidental, on which Judge ad
hominem arguments.
Committed pervasive class error across its typicality, adequacy of representation, and predominance findings by ignoring or discrediting plaintiff expert Dr. Miravet and taking issues of the relative persuasiveness of expert class testimony on common impact, etc., from the jury. Below, no opinions, I want to emphasize here, below the court did not find under Daubert that the opinions of Judge Dr. Miravet were unreliable or inadmissible. So there's no finding in that regard. As the Supreme Court puts it in Tyson's Food, quote, reasonable minds may differ as to the correctness of an expert opinion. Resolving that question, however, is the near exclusive province of the jury, not the chief judge below here. The court in Black versus Occidental Petroleum follows Tyson's in the class context. There, the court rejected the contention that plaintiff's class predominance methodology was incapable of showing class-wide monarchic power. The panel found that this contention, quote, should be properly addressed at trial in a ruling or on a summary judgment motion. Quote, similarly, a challenge to the persuasiveness of plaintiff's methodology for determining market power is in general a matter for the jury. The district court can consider.
Just wrap it up now, if you would.
Yes, sir. We in our brief we go over how the court did not follow Tyson's, and therefore should be reversed on adequacy, representation, typicality, and predominance. Thank you, Your Honor, for your patience. Are we still getting paid double for coming here?
I think it's 30 degrees
We
by
have a
now,
ruling,
so
don't
maybe
we, on
not
that?
this much.
It's got to be below zero for us to get paid double.
Mr. Quinn?
Good morning, and may it please the court. My name is Brian Quinn. I represent C.R.Bard and Bard Access Systems in this case. I'm joined at council tables by my colleague, Colleen Powers. Supreme Court and 10th Circuit law controls each of the three questions that are relevant in this appeal. First, can Parrish establish antitrust standing to bring a tying claim when it never purchased and had no interest in purchasing the tying product, unlike thousands of other hospitals? The answer is no. Second, can Parrish use a voluntary dismissal tactic to engineer appellate and subject matter jurisdiction over the adverse class certification decision on its separate monopolization claim? The answer is no. Finally, even if Parrish could use that tactic to obtain jurisdiction, is there any reason to disturb the district court's class certification decision? The answer is no. Now, Your Honor asked earlier, why isn't this case exactly like sports racing? The answer is that this case is exactly like sports racing. The parallels between sports racing and this case are obvious. As here, the plaintiffs in sports racing brought tying claims and related monopolization claims. As here, one of the plaintiffs in sports racing only bought the so-called tied product. In that case, the tied product was cars and parts. In this case, the tied product is standalone picks. And as here, one of the parties in sports racing brought a claim on the basis of the defendant's alleged monopolization of the market for the tied product. Again, cars and parts in that case. The district court's decision here followed the contours of sports racing as it applies to purchaser antitrust standing exactly. No antitrust standing to bring a tying claim when you only purchase the tied product. Yes, antitrust standing to bring a monopolization claim when you purchase only the tied products and claim an overcharge.
So explain that. They're injured. They state their argument that they are injured by the fact that this tying is going on. It's kind of indirect. There are other people who might be better situated, but why? There's not the complication of measuring damages by allowing them to proceed. Why is that? Why is what would clearly Article 3 standing, why isn't that enough to bring an antitrust claim? Explain the rationale behind that. It's not clear to me.
I think sports racing does a better job than I even could, and where it came out.
It doesn't, I mean, we may be bound by what it said, but that was a fairly brief footnote that you're relying on.
Footnote 15, it was. The rationale of that is that for Clayton Act claims, private antitrust claims, we have to pick the right plaintiff.
Why?
Because the Supreme Court says in Associated General Contractors that as a policy matter, as like, it's just not the case that everybody conceivably injured by an antitrust violation can sue.
Well, I may be getting my cases mixed up, but I thought the big problem there was duplication of damages, because you get different people in the purchasing chain, and let the person who, the wholesaler, I don't know if that was the situation there, they can get all the damages. Yes, the purchasers from the wholesalers are hurt too, but that's going to duplicate damages. What's the negative result of allowing the sort of claim in this case? Well, what problem arises because they're not the best plaintiff?
I think Associated, I think the case you were thinking of, Your Honor, was Illinois Brick.
Yes.
Associated General Contractors is the case where the Supreme Court says that even among direct purchasers, the people who are ostensibly proper plaintiffs to sue, you have to assess directness among them. It's like, we don't want folks with an indirect injury bringing antitrust claims when the people who are best to bring antitrust claims are those who are directly injured. They have the most interest. They're going to detect the violation a lot more easily than someone who's indirect. They've got the most skin in the game in terms of recovery, a possibility for recovery. And so as a policy matter, we don't want to go beyond the first step. We want to focus on the victim who's injured at the first step.
Did the Supreme Court talk about the negative aspects? Maybe these other people are better, but what's wrong with having the case brought by someone who has an indirect injury?
I think it was a proximate cause decision, Your Honor. And so it was really a policy decision about, okay, at some point in time, you just get too far from the locus of the harm, from the direct victim, such that we're not going to allow those people to bring antitrust claims under the Clayton Act. They may have a cause of action under state law that provides for indirect purchaser claims. They may have a cause of action elsewhere, but for purposes of federal antitrust policy, we're going to focus on the direct victim and exclude indirect victims from the ambit of the remedy.
They really don't say what the downside is.
I think the
They just
downside,
say these guys have more skin in the game, they know better, so on, fine, but they don't bring the claim, so an indirectly injured person brings it. But that's a concept that I'm not familiar with outside of antitrust law, that you can't bring a claim unless you're the best person to bring the claim. They don't mention any negative consequences. Are they worried about someone with an indirect claim, I don't know, filing a suit and binding the others in some way so the people who are directly injured can't proceed? Or maybe the people who are directly, quote, injured actually like the situation, so they don't bring the claim? Nothing like that in their opinion?
I think so. There is a portion of the opinion where the Supreme Court in HEC, Associated General Contractor, says the fact that we don't have a direct plaintiff here is indicative of the fact that maybe there's no antitrust violation at all. It's like we have a union, in that case, a union that was suing to recover some kind of damages. And the Supreme Court says there are more direct victims in that case, entities that are letting construction contracts and are the direct victims of the alleged coercion. It's like the fact that none of them have sued, like in this case, none of the thousands of hospitals that purchased the tying product have sued, indicates that there's no violation to deal with in the first place. And we don't want to allow a kind of attenuative and contrived claims in.
It's kind of like if the direct people aren't complaining, then why? Okay.
I think that's the crux of the argument. I think so. And that was really the basis for sports racing. The court said, look, I've identified an entire cohort of people who are the direct victims of the alleged tying policy. They're the right ones to bring the claim. You who only purchase the tied product, you're never subject to the coercion, and you only suffer an injury to the extent that these earlier people suffer an injury. And that's true of Parrish as well. Parrish never suffers an injury unless and until thousands of bundled purchasers actually suffer an injury.
Counsel, I heard Parrish's argument to be that, Abraham sports racing largely is either dicta or relying upon dicta. But why should we read sports racing so firmly to be sort of the exclusive list of who can have standing to bring the tying claim? In other words, it says there are two types of parties. It doesn't say there are only two types of parties. So help me understand that.
Sure. So the entire decision in sports racing on purchaser antitrust tying standing hinges on the notion that there's no other purchaser who could bring that tying claim. The court says of Freeman, the party who actually purchased the bundle in that case, it's like, even though you purchased the tied product indirectly, you purchased it through another party, we're going to carve out an exception to the Illinois BRIC rule on indirect purchasers because we think that you're the right person to bring the claim. You're the right purchaser plaintiff to bring a tying claim. It says of SRS, the party that only purchased the tied product, you are not the right person to bring the claim. You're not tied. You haven't even suffered any antitrust injury that we can tell. And there's another direct victim standing right here. And so the entire decision on doing something, carving out an exception to Illinois BRIC is no mean thing. The entire decision to do that hinges on the court's conclusion that the tied product purchasers only was not the proper plaintiff to bring a tying claim. Now, when it came to monopolization, the sports racing court said, this is an analytically distinct claim. There are different elements that you have to prove for this claim. The theory of injury is different. The theory of injury in a monopoly maintenance claim like Parrish's is that the monopolist is already charging super competitive prices in the market and then does something exclusionary. At that minute, everybody who purchases the product is injured. And so purchasers of the bundle and a purchaser like Parrish that only purchases the tied product is injured in that moment in time. And so it really maps on to this case quite well. It's kind of the exact same scenario. I would like to take a chance to respond to some of the jurisdictional arguments that Parrish made on Anderson Living Trust and on Microsoft v. Baker. I think that argument boils down to this merger argument that Parrish is making. As I understand it, Parrish says that the order dismissing its separate tying claim merges into the judgment and somehow makes the interlocutory order on its separate class certification claim appealable under Anderson Living Trust and under Baker. And I just don't think that's right. Anderson Living Trust itself addressed a merger issue. The court said of the Anderson Living Trust, it settles its claim, and then it voluntarily dismisses the claim. In that opinion, the court says that class certification order, that adverse class certification order, doesn't merge into the final judgment because the Anderson Living Trust disassociated itself from the class. By dismissing its individual residual claim, it divorced itself from the interest of the class, such that the adverse class certification order never merges into the final judgment and doesn't become appealable. I think that's the answer here. Parrish dismissed its residual monopolization claim. It dismissed it with prejudice. It said, we let it go. That claim is now gone forever. It divorced itself from the class such that the adverse class certification order doesn't merge into the final judgment and doesn't become appealable. Kind of an adverse finding, you can imagine in Microsoft v. Baker, the same issue would have come up. The Supreme Court would have held in that case that the issue was not appealable. Well, under Parrish's logic, that class certification order would have merged into the final judgment and been appealable. And so I don't understand the distinction that Parrish is trying to make there, and I don't think it's cognizable under Anderson Living Trust.
Counsel, I think it was either in your motion or one of perhaps your response, though, in applying Microsoft v. Baker, you also argued that Parrish lacks Article 3 standing, but I read Microsoft v. Baker to be a 1291 finality decision. So why do they lack Article 3 standing as well?
So you're absolutely right, Your Honor. Microsoft v. Baker was a decision that was premised on appellate standing rather than Article 3 standing. 3 justices wrote separately to indicate that they believed that the plaintiff in that case lacked Article 3 standing. And so I still think that in a case like this, where the plaintiff made no reservation of rights below, Parrish made no reservation of rights on its residual claim, unlike the plaintiffs in Microsoft and Anderson Living Trust, I believe, that plaintiff lacks Article 3 standing on appeal. It dismissed its claim with prejudice, and the question for Parrish now is, even if it gets a favorable result on appeal, like how does it revive that claim at the district court stage, having dismissed it with prejudice? Like that claim is gone forever.
Well, the dismissal was against just the one party who wants to be the class representative.
Right.
And I think the argument is that it could be continued as a class action.
That's absolutely.
Which has happened, I think it was a case involving prisoners, had class action and the purported representative was released from prison, but the case could continue with the other class members. I assume that that's what they're talking about here.
Maybe that's the case. I didn't see that case in their briefing. There is no other named plaintiff here in this case, though. Parrish is the only named plaintiff. And so there's no one left, really, at the district court stage to prosecute the case. And so without any residual interest in the case at all, it's unclear how Parrish prosecutes the monopolization claim, even if it prevails. I see I'm running low on time, and so I did want to briefly address the class certification arguments that we heard. I think it was Tyson that Counsel for Parrish mentioned, and he also mentioned taking merits issue from the jury. I don't think the district court violated Tyson at all. Tyson arose after a jury verdict in that case, and the Supreme Court in that case said, with respect to pure merits issues, when there's a battle of the experts, the court should defer those issues to the jury. It did not say that district courts conducting a Rule 23 analysis, once they make an admissibility determination, they dust their hands and say, I'm done. I adopt wholesale the plaintiff's expert testimony. My hands are tied because I can't make a summary judgment finding on this record. I think, if you think about the rigorous analysis that district courts are supposed to perform at the Rule 23 stage, there's really no ambit for that under Mr. Berry's reading of Tyson. The admissibility determination is everything, and then that's it. And so maybe we'll hear from him when he gets back up as to what he thinks the proper role of the district court is under Rule 23, and whether it's only making admissibility determinations and then adopting expert testimony wholesale. So unless the panel has any other questions, I'm happy to answer. Thank you very much for your time.
Counsel, you're not entitled to any, but because you came here in this weather, I'm going to give you 2 minutes.
2 minutes?
3? No more than 3. I'm going to cut you off at 3, literally.
I can't get 5.
No.
Your Honor, as to that distinction about Tyson's only goes to merits, persuasiveness of experts rather than class, common impact issues, the Supreme Court in Tyson's says, a district court cannot decline certification merely considers a plaintiff's evidence relating to common class actions to be unpersuasive and unlikely to succeed. It's talking about class issues. It's not talking about their contorted reading that it only goes to merits issues at trial. So Tyson's food on its haec verba applies here. As to the Supreme Court never has said you need to be the best litigant or the best private enforcer of the antitrust laws. You just need to have the requisite standing in antitrust price injury. Once again, Anderson Living Trust did not have a prejudicial ruling on a major merits decision before it, a final decision. It was not there. And you can't apply Anderson Living Trust to something that it doesn't address. This court should look to Crowley Petroleum, it should look to Schmier, and it should look to the Corley 11th Circuit merger case that we also cite, and I didn't have time to discuss. However, moving on, I want to address quickly on the class issues. I didn't finish up on typicality. Let me just read for the record where Miravet's testimony was ignored or discredited by the district court under Tyson's. Typicality, Appendix 9698, adequacy of representation, Appendix 100, 103, predominance 106, 112. If you check the record, you'll find that now as to typicality, Dr. Miravet testified, because more competition produces lower prices, and this is an initial in his reply reports, all class members are injured by the PIC overcharging, and the court's typicality reasoning does not apply. Also, there are two other issues on error on typicality. One, the Court of Appeals in Zeta and Lorazepam, DC Circuit, Fourth Circuit, have found standing issues are not relevant to typicality. The court went off on standing and typicality. That's the wrong analysis. Secondly, the district court fundamentally misunderstood this antitrust standing query on the merits, saying Parrish suffered no PIC overcharge injury because it liked the Bard PICs. The issue is there antitrust price injury, not whether you liked them or disliked the monopolized product, and I'm out of time. Thank you, Your Honor. Thank you for your consideration.
The case is submitted. Counsel are excused. We'll be in recess until 9 tomorrow morning.
Court is in recess.
Now she holds.